Good morning, everyone out there in YouTube land. Thank you for bearing with us this morning. We're running a little bit behind, but students haven't arrived yet. And thanks to everyone who's come over from Facebook. My apologies, we couldn't get live set up this morning, but it's going to take a little more time than we had. And speak of the devils, the students are arriving. So, welcome everyone. All right, so witnesses in the gallery. Everybody come in, come in, come in. Everybody involved in the courtroom. All right, for traffic direction purposes, raise your hand if you are a juror. Raise your hand if you are a juror. All right, then I need you to come up. You should come up into the well. And then please proceed into the jury box. You will find pins that are labeled juror in each seat where you can sit. One of the seats is slightly broken or recovering from being slightly broken. So please do not sit in the seat that does not have a pin in it. And once you have found your seat, please put on your juror pin to indicate to the entire world that you are, in fact, a juror. So do not sit there. Do not sit there. The one that is on the one that so So jurors, are you impaneling yourselves or are we going to be standing? Are we going to be standing around all day? Because I can't keep directing traffic until everyone's set. All right. All right, our jurors are in place. All right, raise your hand if you are an attorney for the state of Kansas. Attorneys for the state, come up to my right. My right. So at the council table should be the first chair and the person making the opening statement at this time, if they are different. First chair's team lead, whoever that is. Right, raise your hand if you are an attorney for the defense. Right, defense, come up to my left, same deal. And I would also like the defendant to also come up and take a seat at defense counsel table. Yep. All right, folks, and witnesses are free to have a seat in the gallery, preferably in the first half because we don't know who's going to be coming and going today. So you are in the hot seat when you are an attorney who is doing direct examination. You will have the option of conducting direct examination either from your chair where you're seated and speaking into the microphone that's in front of you, or you will have the option of getting up and walking around, hopefully using the podium that's been provided for you as well. So, in the event that you do wish to do that, in front of you, you should find a black bag. So in front of, by the black stacker, in front of you, behind the laptop, behind your laptop, yes. You'd please grab that. If lead counsel will grab that, open it up, make sure you know what's in it. You're gonna find a wireless lapel mic. So if you want to get up and walk around, that's fine. If you guys want to remove them and turn them on now, that's fine. But alternatively, simply to turn them on, simply hold the power button and they'll turn on. Power button's located at the top of them. Everyone who is present who has a laptop, there is power available both at your feet for counsel. Well, for defense counsel, it's going to be on the table to your, well, for the state, it's going to be on the table to your right, on the back of the, behind the printer. Behind the printer are a couple of outlets. And for the defense, there is one that's at the feet of, that could be, that I will momentarily get up and slide over to you. Folks who are not at counsel table, there is also power strip at your feet, a bit, or there should be one for each side that's got 12 outlets on it, or 10 or 12. That should be more than enough for whatever you guys need power-wise this morning. In the event the folks in the gallery who are witnesses also need to fish power lines over, that is fine. Additionally, there is a single white binder up here by the podium. That is the exhibits binder, where it only has exhibits in it. If there's an exhibit that you wish to show a witness or have admitted into evidence, we're going to pull it out of that binder and not out of your materials that are in front of you. All right. Are there any questions with regards to the resources that are immediately available? Also, if you would like to use the large monitors in front of you, we can simply HDMI them into your computers, or you can also use the computers they're attached to if that is more your speed. If you don't have your laptop and for some reason you decide that you want or need it. All right, so that takes care of preliminary matters. We are somewhat time limited today. We must be done by, Mr. McIntosh, what is our hard deadline to be done? Goal is by noon, but what is the drop dead? We cannot exceed time limit. So, yep. So we are done by 12:30. If you have not finished presenting your cases by 12:30, someone's getting strangled because it should not take 4.5 hours to present these cases. That being said, this is your final, everybody. So you guys, so take all the time that you need. Do not feel rushed. Other than that, do keep an eye on the clock because we do have a drop dead time. So then the way this is going to work is that the state will present its case, defense will present its case, and then the jury will be given an opportunity to deliberate on the guilt of the defendant in this matter. Should the defendant be convicted, the jury will then have more jury instructions read to them, and the jury will adjourn to address sentencing in this matter. Because unlike in the real world, in this fictional state of Kansas, the jury is heavily responsible for sentencing. So then, I have some normal jury instructions that I read at the start of the matter when we get underway. But before we can get underway, we have some pretrial motions to address, because it has been brought to the court's attention that some shenanigans have been occurring, both in that there is some evidence that has been presented to the state that has purportedly been leaked from internal discussions by the defense. So then, would the state be so kind as to explain just what the heck is going on here? And please speak into the microphone.
There was a picture leaked to us that contained some language that could be used against Mr. Johnson in the court.
So there is an image that you would like to add that is an exhibit that is not part of the case materials?
We've decided that we are not going to use it.
All right. Are you going to seek any testimony regarding it?
No.
Who leaked it?
I'm not exactly sure. It was only brought to my attention from my fellow lawyers.
Then I will look to, is there anyone from the state who knows the source of the leak? All right, hearing none from the state, I will give the defense an opportunity. If the defense has something it would like to advise the court of, now would be a very good time to do it, because leaking of confidential discussions is highly unethical. And if you would like an opportunity to not have the court's dander up, this is your one and only opportunity to address that. I cannot help but hear nothing but silence from the defense.
We have nothing to say, Your Honor.
So you do not contest that a member of your team leaked confidential discussions regarding the representation of your client to the state?
No.
So you do not contest that. All right. Who was it?
It wasn't somebody from our side.
But you just said you don't contest that it was someone from your side.
I didn't mean to say that.
All right, so counsel, how then did a confidential discussion, because this was a Snapchat group, correct?
Yes.
And it was limited only to members of the defense and the defendant, correct?
No.
It was public? You were having public discussions about the representation of your client?
It was a discussion between the peers in the class.
So then you were having a discussion about the representation of your client in a conversation that the state was privy to, as well as the jury. I'm simply trying to understand how this happened, because it can't have been leaked if the state was privy to it from the beginning. In which case, that's just bad lawyering. And whatever malpractice that might be, it's beyond the scope of what this court can deal with.
Chris Johnson posted something that was self-incriminating.
Yes, but who received it? Was it to a group? Was it to a private group that was just his attorneys, or was it to the entire class?
The entire class.
All right. So then I suppose then you guys don't have the defense does not have an ethical issue, which is good. But at the same time, the defense should be very glad the state is not intending to use it, because by doing that, the defendant waived all potential claims of privilege. So as this was not leaked, the court has no real reason to be unhappy other than to comment upon the defendant's poor judgment in doing so. And beyond that, as the state has said it does not intend to use that evidence in the first place, there's no issues having to deal with a motion in limine at this time. All right. So then, are there any other preliminary matters that need to be addressed before I begin what I need to do to welcome everyone here today? Anything from the state?
No.
Anything from the defense?
No.
Anything from the administrative side of things? Hearing nothing then, would each member of the jury please raise your right hand? Do each of you swear to do your duty as a juror in this matter, to faithfully hear the evidence presented and render a verdict in accord with that evidence? Everyone must audibly answer. Thank you. You may lower your hands. Now that you have been sworn and before the presentation of evidence, I have the following preliminary instructions for you for guidance as jurors in this case. You and only you will be the judges of the facts. You will have to decide what happened. You should not take anything I say or do during a trial as indicating what I think of the evidence or what your verdict should be. My role is to be the judge of the law. I will make legal decisions during the trial, and I will explain to you legal principles that must guide your decisions. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide this case. The evidence from which you are to find the facts consists of the following: the testimony of the witnesses, documents and other items received as exhibits, and any facts that are stipulated to, that is, that are formally agreed to by both of the parties. The following things are not evidence: statements, arguments, and questions of the lawyers for the parties in this case, objections by the lawyers, any testimony I tell you to disregard, and anything you may see or hear about this case outside of the courtroom. You must make your decision based only on the evidence presented in court. Do not let rumors, suspicions, or anything seen or heard outside of court influence your decision in any way. You should use your common sense in weighing the evidence. Consider it in light of your everyday experience with people and events, and give it whatever weight you believe it deserves. Certain rules control what can be received into evidence. When a lawyer asks a question or offers an exhibit into evidence, and a lawyer on the other side thinks that that is not permitted by the rules of evidence, that lawyer may object. An objection simply means that the lawyer is requesting that I make a decision on a particular rule of evidence. Objections to questions are not evidence. You should not be influenced by any objection, or by my ruling on that objection. If the objection is sustained, ignore the question. If it is overruled, treat the answer like any other. Evidence may be either direct or circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw, heard, or did. Circumstantial evidence is proof of one or more facts from which you could find another fact. You should consider both kinds of evidence. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. You may decide the case solely based on circumstantial evidence. In deciding the facts, you must determine what testimony you believe and what testimony you do not believe. You are the sole judges of the credibility or believability of the witnesses. You may believe all, some, or none of a witness's testimony. In deciding which testimony to believe, you should use the same tests of truthfulness as in your everyday lives, including the following factors: the ability of the witness to see, hear, or know the things the witness testifies to, the quality of the witness's understanding and memory, the witness's manner and behavior while testifying, the witness's interest in the outcome of the case or any motive of bias or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and how reasonable the witness's testimony is when considered in the light of the other evidence that you believe. Inconsistencies or discrepancies within a witness's testimony or between the testimonies of different witnesses may or may not cause you to believe a witness's testimony. Two or more persons witnessing an event may simply see or hear it differently. Mistaken recollection, like a person's failure to recall, is a common human experience. In weighing the effect of an inconsistency, you should also consider whether it was about a matter of importance or an insignificant detail. You should also consider whether the inconsistency was innocent or intentional. The weight of the evidence to prove a fact does not necessarily depend on the number of witnesses who testified or the quantity of evidence that was presented. More important is how believable the witnesses were and how much weight you think their testimony deserves. You will now hear the opening statements of the parties and the presentation of evidence. At the conclusion of the evidence, I will instruct you on the law that you are to apply to the facts. Does the state have an opening statement that it wishes to make?
Yes.
All right, I will yield the floor to the state to make its opening statement.
Ladies and gentlemen of the jury, there is one reason we are here today, and that reason is anger. While anger is a powerful emotion, it does not give us the right to break the law. The defendant, Chris Johnson's pursuit for revenge. Mr. Johnson's objective of revenge all started when my client, Blair Rogers, won the lottery. Mr. Johnson believed that he should have received more of her winnings and that she should have been more financially responsible. After this event with Chris, he became more distant and jealous of Miss Rogers. The friendship became more strained as Chris failed to keep his dog caged and safe behind a fence. Chris's dog was then struck with Blair's vehicle and killed. It seemed as this was the last straw for Chris. He then asked Blair to have a party at her house so he could plan his revenge. He started a fire in her garage, destroying her new Cybertruck, part of the house, in a valued friendship. May it please the court, Your Honor, opposing counsel, and members of the jury. My name is Addison Dykeman, and I'm representing the state in this action. The defendant now stands trial for arson on 2 counts for ruining Blair's Cybertruck and garage on December 20th because of his anger and journey for revenge. In this case, we will show that the defendant, Mr. Johnson, is guilty, and he deliberately set fire to the Cybertruck in order to destroy it. He planned this act of destruction when he asked Blair to have a party at her house, giving him clear access to the garage. For our witnesses, we will call Mr. Bellow. He's a professor, a next-door neighbor, and an eyewitness who saw Chris going into the garage as if he was out of breath. He was there when the fire started and there when the department was called. We will then hear from our expert witness, Miss Jess Maldonado, who will explain the V-shaped flames of our characteristics of arson. And we will also hear from the victim, Miss Blair Rogers. She will tell us how angry and jealous Chris seemed. She will tell you how he was extremely mad at Blair for hitting his dog and being irresponsible with her money. The defense, however, may tell you that this is an electrical fire and that Chris was at the movies the whole time this was going on. But our evidence and our testimonies will prove that this is clearly incorrect. Our eyewitnesses very clearly saw Chris walking into Blair's garage. Will explain how the V patterns are very characteristic of arson and just how much Chris was holding against Blair to ruin this friendship. Chris Johnson is guilty today, and we will strive to prove this beyond a reasonable doubt. Mr. Johnson not only destroyed a Cybertruck, but he destroyed a friendship. That's all.
Thank you. Does the defense have an opening statement?
Yes.
All right. I will yield the floor to the defense to make its opening statement. If the defendant would please move down to the 3rd seat provided.
Your Honor, may I please stand?
You may. At the top of the unit, flip it long ways. No, flip top. There's a big old power button. Just press and hold it. It'll come on. You can just carry it unless you're going to be using your hands for, or put it in your pocket. That works too.
Can you hear me okay?
Yeah, you mount it so that it's facing upward. The mic's facing upward.
Does this work? Or is it?
Not brilliant, but it'll work.
Right there, okay?
That works.
Good morning, esteemed members of the jury. I am Brisa Montes, a defensive lawyer. The lead attorney, Jocelyn Montes, has entrusted me to represent the case today. Mr. Johnson has entrusted the defense team with the responsibility of representing him in this matter. Mr. Johnson has been accused of the following criminal accusations: 2 counts of arson, a level 6 and 7. As we are all aware, felonies are serious criminal accusations that can permanently ruin Mr. Johnson's life and reputation. Mr. Johnson is no arsonist. He is attending Camden with a passion for law. We hope that one day Mr. Johnson will be able to attend law school, something we all once dreamed of in this courtroom. So we ask you, the jury today, to be cautious in the decision that you choose, as a bright young man's future is in your hands. To prove this, we will be bringing Riley Goldman, who will provide a concrete timeline and a clear alibi that Chris Johnson was not the one who started or involved in the fire. We will then be bringing up Pat Kendrick, an expert in electrical fires. She will be proving. For evidence, we will be providing and reviewing photos of the movie tickets, photos of the fire, Blair's house layout, and Jess Maldonado's origin and cause report of the fire. Now, let's dive into this case from the beginning, where it all started. Chris Johnson and Blair Rogers were good friends. Some might even say best friends. On Blair's 18th birthday, she received a sum of money from Chris to celebrate she was old enough to gamble. Blair placed sporting bets, winning 5 out of the 7. And with the earnings, she decided to buy a Tesla Cybertruck and gave Chris Johnson $3,000 as a thank you in his mailbox. On December 20th, 2024, Blair invited Chris and Riley to her pool party, which began at 1 p.m. After enjoying this party, Chris and Riley Ubered to the movie theaters to watch a Harry Potter movie marathon, which started at 4 p.m. with no re-entry. Immersed into the movies, they occasionally took bathroom breaks and snack breaks and nodded off during the slower parts of the film, all while immersed in the movies, gripping their seats. Now, after the movies, Chris Johnson decides to head home, but gets a call from Blair informing him of the fire. Chris, being worried for his friend, met up with Blair for coffee the next morning at 11 a.m. After this interaction, Blair gets hit with accusations of guilt. And so, it is essential that we cast light behind these accusations and to address any differences that may arise during the course of this trial. As a defense team, our primary goal is to ensure that justice triumphs and that facts are presented clearly and accurately. We appreciate the opportunity to present our case before this honorable court and trust that through thorough examination and careful consideration of the evidence, the truth will prevail. At the conclusion of this case, you will have reasonable doubts that our client, Chris Johnson, was not anywhere near the fire when it started. If anything, you will be convinced that the Tesla Cybertruck, lithium batteries, and house wiring played a key role in the start of the fire. Consequently, Chris Johnson is simply not guilty of the false accusations presented. Thank you for your time and consideration. That is my honor.
Thank you. All right, I will yield the floor to the state to present its case in chief. But before we begin that, for folks who may need something to write on, if you do not have a tablet and want one, is there anyone who requires a tablet? Who does not have one? No? Well, should it be needed, they are over by the door, and I'm sure Mr. McIntosh would gladly get them if someone made a request for one. So then, I believe that's the only other preliminary matter I've thought of between now and during opening statements. So then I will yield to the state to call its first witness. And Ms. Dyke, are you the examiner for your side on this witness?
Yes.
All right.
We'll call Blair Rogers to the stand.
Right. Ms. Rogers? You'd please come up, have a seat in the witness box. Have a seat. Get comfortable. Make sure the microphone's in front of you so that you can speak into it clearly. Yes. That's why I said get comfortable. All right, ma'am. All right, ma'am, if you please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
Would you please state both your character's name and your actual name for the record?
Blair Rogers and Emily Pena.
All right, Ms. Rogers, if you please lower your right hand. The witness has been sworn and has furnished their name for the record. The floor is now the state's to conduct its direct examination of this witness.
Miss Rogers, could you please state your address?
It was 1196 Fall Creek Road.
And do you own this house?
Yes,
How long have you been in possession of this house?
since middle school.
How did you come into possession of this house? That's what I meant, sorry.
It was my grandpa's, but he passed away, so he left it to me.
And did you meet the defendant while living in this neighborhood?
Yes,
Does the defendant does the defendant live in the same neighborhood?
yes,
How long have you known the defendant?
since middle school.
How did you and Mr. Johnson become friends?
When I was getting bullied, he stood up for me, and then we became friends after that.
And did you ever want to be anything more than friends with Mr. Johnson?
Thought of him as a brother.
Did you ever feel like Chris wanted to be more than friends?
Sometimes yes, but I just thought he was being super friendly.
Did this strain your friendship in any way, cause any problems?
No.
Did Chris and you do anything for your birthday?
Yes,
What did he take you to do?
we went mini golfing.
After the mini golf, did you do anything else?
We went back to my grandpa's house, and he gave me some money to play sporting bets.
How much money did he give you?
$5.
Did you only use the $5 for these sports bets?
No, I added $5 more from my account to make 10.
And how many bets did you place?
I placed 4 bets.
Did you end up winning any money?
Yes,
How much did you win?
$400,000.
And what did you end up doing with this winning money?
I gave $3,000 to Chris, and then I used the rest of it to buy something else.
Why did you feel the need to give Chris some of your winning money?
I thought that would be a good thing for me to do as a good friend, to give him money back since he gave me money for my birthday.
Did you think Chris was thankful for the money he was receiving?
No, I felt like he expected more.
Why do you think he expected more of the money?
I think he expected more of the money because he gave me money for my birthday.
What did you do with the rest of your winning money?
I used it to buy a Tesla Cybertruck.
And was there a particular reason you bought this Cybertruck?
I used it because it was good for the economy since it's electric, and I was going to be traveling to college.
And do you currently attend college now?
Yes,
What college do you attend?
Oxwell.
Does Chris go to the same college?
No, he didn't get accepted.
Were you upset that he didn't get accepted?
No. Well, at first, yes, but then I thought it'd be a good thing to do because we needed to branch out and make other friends.
So you did not want to go to the same college as him?
At first, yes, but then I thought it was a good idea to branch out and make new friends.
And after buying the Cybertruck, did anything happen between you and Mr. Johnson?
Yes, a little accident happened.
Could you please walk us through what happened?
I left my grandpa's house upset, and I was distracted while driving, and I accidentally hit his dog.
Why were you upset while driving?
I just found out that my grandpa wasn't doing so well, and I didn't know when the last time I was going to see him was going to be.
So did you purposely hit Chris's dog?
No,
Did the dog survive this accident?
fortunately, no.
Did Chris seem angry at you?
Yes, he seemed livid.
What did he seem angry about?
He seemed angry about his dog, but more about being irresponsible with my money.
Why did he seem so angry about your money?
I don't know the exact reason, but I think because he thought I should have used it for college
Did you apologize for hitting his dog?
multiple times.
Did anything else happen after this accident?
No,
How did yours and Chris's friendship change after this encounter?
we became distant.
So, could you please walk the jury through the events of December 20th, 2024?
We had a party at my house.
Why did you want to have a party?
Chris asked me to have this party at my house.
So, just to clarify, it was Chris's idea for the party?
Yes, ma'am.
Why did Chris want to have a party at your house?
Because I have a pool in my backyard.
And who was invited to this party?
Friends from high school that were back in town, some friends from college, and Chris.
Did Chris bring anybody else with him to the party?
His girlfriend, Riley.
Did that upset you that he brought Riley?
She was a little weird, so I didn't really mind.
Did you feel that Riley was ever jealous of you?
I don't really know. I wasn't really around Chris and Riley that much.
So at the party, did Chris seem like he was acting differently than he had
Yes.
been previously? How was he acting different?
Felt he was more cheerful and happy.
And do you remember the exact time that Chris and Riley arrived at your party?
I don't.
Did Chris help pay for anything during the party?
No.
Do you know where they went after? Oh, sorry, wrong thing. Do you know what time they left the party?
I don't know not sure what time they left, but they weren't there when we gathered for dinner.
Do you know where they went?
I'm not sure.
Did they say goodbye before they left?
No, they left without saying no words.
What happened for the remainder of the party?
The rest of us hung out, and most people left by about 7:45 p.m.
What did the rest of you guys do for the remainder of the party?
We went to the movie theater for the movie marathon.
And how did you get to the movie theater?
We Ubered there.
And if someone were to walk to the movie theater, how long would it take them?
About 10 to 15 minutes.
So what time did you arrive to the movie theater?
We got there at 8:50 p.m.
What did you do while at the theater?
We waited for the third movie to start.
Did you see Chris and Riley at the movie theater at all?
No, not once.
Were you able to watch the third movie?
No.
Why?
I got a phone call from the fire department
What did they say?
that my house was burning down.
And what time did you get this phone call?
About 9 p.m.
So how long did it take you to make it back home?
About 10 minutes because I ran.
So how far is your house from the movie theater?
About 10 minutes if you run.
And what time did you arrive home?
9:10 p.m.
And what did you see upon arriving back home?
I saw part of my house burning down.
Who did you see at the scene?
A bunch of firefighters. But I couldn't really see because it was really dark outside.
Did you see anybody else other than the firefighters?
No, ma'am.
I have no further questions at this time.
All right, and Ms. Montez, will you be doing the cross-examination?
Yes.
I will yield the floor to you for cross then.
Okay. Chris never actually told you he was angry about your winnings, did he?
Can you restate that, please?
Chris never told you that he was upset about your winnings.
Can you rephrase that?
Did the defendant ever tell you he was unhappy about your winnings?
No, he just seemed mad.
Ms. Montez, is that a fair rephrasing of the question?
Yes.
The floor remains yours.
Would you agree that you and Chris had grown apart since high school?
I felt we grew apart whenever the accident happened.
Would you agree that you had some negative feelings towards Chris for some time?
No,
After winning the money, did Chris ever tell you personally that he was upset for how much money he gave you?
he didn't give me any money.
I meant for how much money you gave him.
No, he just seemed super angry by yelling at me about how irresponsible I was with my money.
Did Chris ever ask you for more money?
No,
You didn't exactly notice when Chris and Riley arrived, did you?
no,
And you can't say for certain what time Chris left the party, can you?
no, they were not there when we gathered for dinner, though, which was about 6:30 p.m.
There were many people at your house that day, were there?
Yeah, a few friends.
There were many people coming and going that day, correct?
Yes,
During your party, did your guest have any access to your garage?
yes,
You can't say whether anyone entered the garage during your party, can you?
no, because most people were outside.
When you left for the movies, you didn't see Chris at your house at 8:45 p.m., correct?
No, I left for the movies at around 8:50 p.m.
Do you have cameras in your house?
No,
And you don't have any direct evidence that Chris entered that garage the day before you left?
no,
And you can't say whether anyone entered the garage during the party, can you?
no, I was busy talking to other friends.
You never actually saw Chris at your house the night of the fire, did you?
No,
And you didn't see Chris holding anything flammable, correct?
correct.
And you don't have any videos or photos of Chris near the garage that night, do you?
Correct.
You went to the movie theater at 8:50 with others. Did Chris go too?
I'm not exactly sure where Chris went.
You got a call from the fire department at 9:53 p.m., correct?
I got a call from the fire department at 9 p.m., ma'am.
You live a mile away from the theater, and you made it in 10 minutes, so the fire was already burning when you arrived?
Yes,
No further questions, Your Honor.
Right. Is there any redirect from the state?
Yes.
The floor is the state's for redirect.
Were all of your doors unlocked in your house?
yes,
So anyone could have entered any part of your house. Nothing was locked.
yes, ma'am.
Did Chris ever tell you thank you for giving him the $3,000?
No, ma'am.
So, mm. So it did seem like he was upset about you
Yes,
not giving him. Where did you put his money at?
I slid it under his door.
Why didn't you hand it to him personally?
I thought it would be a fun surprise for him to find.
You were never angry at Chris for anything before now.
No, ma'am.
Did you talk to Chris at all at the party?
No,
Okay. I don't have any further questions.
Right. Is there any recross from the state?
Yes.
Floor is the state's.
Other than your own feelings, you don't have any proof that Chris wanted to hurt you, correct?
Yes.
Chris never directly threatened to harm you or any property, did he?
Correct.
You inherited your grandfather's home, is that correct?
Yes, ma'am.
Can you please state when you inherited your home?
When I was in college, because my grandpa had passed away when I was away at college.
Earlier, you had stated that you inherited your home in middle school.
I stated that I lived there since middle school.
Could you state why none of your doors were locked during this party?
Didn't really think I had to lock them.
Are you aware that Jess Maldonado confirmed that the doors were sealed?
Objection. Ooh.
Base for the objection, counsel?
Relevance. It was never brought up in direct questioning.
So your objection is to foundation,
Yeah,
not
foundation.
relevance.
Yeah, sorry.
Response of the defense?
It's something brought up in redirect.
When? If other counsel would like to step up and make an argument to simplify the game of telephone, they're welcome to.
No.
All right, then the hot then Ms. Montez, you're in the hot seat. So when in redirect was Jess Maldonado brought up at all?
He wasn't.
So then you would agree there is no foundation for the question.
Yes.
Do you want to try to develop some foundation?
Yes.
I will sustain the objection for the moment, but I will provide an opportunity to develop foundation. So,
Okay.
Ms. Montez, if you want to take a stab at developing some foundation, the floor is yours.
All right. Going back to your Cybertruck, where did you keep your Cybertruck?
Garage.
Could you please state how you would charge your Cybertruck?
It's electric, so with the charger.
Did somebody do electrical work for this?
Yes.
You made an insurance claim for your house, correct?
Yes.
No further questions, Your Honor.
All right. I did have one question as a result of your testimony, Ms. Rogers. Stated you won $400,000. So third of that goes to taxes. Then you gave $3,000 to Mr. Johnson. So we'll call that 140. Call that 140 grand. And then you bought a Cybertruck. How much was the Cybertruck?
I'm not exactly sure the price, but it was around there after taxes, insurance, and all that.
So it was around how much do you think it was?
140.
Okay, so you got 400. 140 went to taxes and Mr. Johnson. You spent another 140 on the Cybertruck. So where'd the remaining 120 go?
It was used on taxes and insurance.
No, we just stipulated that 140, a third went to taxes, And so then you said the Cybertruck cost you 140. So that still leaves 120. Where'd that go?
Not exactly sure.
All right. Would the state like to do any cross-examination based on the questions that I have asked?
No, Your Honor.
All right. Would the defense like to do any cross-examination based on questions I've asked?
No, Your Honor.
All right. Then this witness may step down. Thank you. Remember that you remain sworn. All right. State like to call its next witness.
Our next witness is going to be Mr. Drew Bellow.
All right. Mr. Dubello would please come on up. Please have a seat, sir. Get comfortable. Make sure the mic's well placed. All right, and once all that's done, sir, I'm going to need you to raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
Right. Please, you may lower your right hand. Would you please state your character's name for the record as well as your actual name?
Drew Bellow and Alvaro Leyva.
All right, then, Mr. Bellow. Mr. Bellow has been sworn, so the attorney, the examiner for this particular witness, I would ask that you also state your name for the record.
Brody Keller.
All right, then, Mr. Keller, the floor is yours to conduct your direct examination.
Please state your current occupation for the record.
Professor at Wichita State University.
And can you please provide your current address for the record?
1194 Fall Creek Road,
Where do you live in proximity to Miss Rogers?
west of her.
How do you know Miss Rogers?
I've known her since she moved in.
Was there anything going on at Miss Rogers' house the day of the fire or December 20th?
A party.
How do you know?
I could hear them.
Do you know the defendant, Mr. Johnson?
Yes.
How?
He's lived in my neighborhood.
Did you ever see the defendant at Blair's house?
Yes.
When?
Around 8 p.m.
What were you doing when you saw the defendant at Blair's house?
I was chasing my cat, Melvin.
What did you see the defendant do?
I saw him walk on the side of Blair's garage, like he was out of breath, and then he went inside.
And you said that was around 8? After retrieving your cat, what did you do?
I went back inside
Why'd you go inside?
because I got my cat.
Did you ever go back outside?
Yes,
Why did you go back outside?
to check on my experiments
And what time was this?
around 9 p.m.
Did you notice anything different when you went back outside?
It smelled weird.
Did you take any action after noticing this change?
I ran to the front and I saw smoke coming out of the garage. So I went to the front door to see if anyone would answer.
Did you see anyone inside?
No,
Did you hear anyone?
yes,
At this moment, was there any communication with law enforcement?
yes,
Did you communicate
yes.
with, you did? What was the instructions or information that the dispatcher told you to do?
She told me to knock on the door to see if anyone would answer.
Did anyone answer?
No,
What did you do after receiving no answer at the door?
I went back to my house to get the spare key Blair's grandparents gave me for emergencies.
Did you notice anything different when you were running back?
I saw low V-shaped flames in the garage.
After getting the spare key, were you able to enter the house?
I was about to unlock it, but the fire department tapped my shoulder and told me to go across the street.
As you crossed the street, did you see anyone else?
Chris Johnson,
How are you certain that it was Chris Johnson?
he was wearing the same things from earlier when he went inside the house.
No further questions, Your Honor.
All right, then, ma'am, if you please state your name for the record.
Brianna Orozco.
All right, Ms. Orozco, the floor is yours to conduct your cross-examination of this witness.
Mr. Drew, I would like to start off talking about your proximity to the house. Approximately how long did it take you to get from your house to Blair's house?
Couple minutes,
How long is a couple minutes?
2-3 minutes.
Can you restate the time that you first went out?
8 p.m.
And it was at this time, 8 p.m., that you allegedly saw Chris?
Yes,
How did you know it was him?
I've known him for a long time. I know how he looks.
Did you see his face?
No,
Was he walking away from you or towards you?
away.
You only saw the back of this person.
Yes,
And at this time, you stated that there was multiple people walking out of the house, correct?
can you say that again?
At this time, you stated that there was multiple people walking in and out of the house, correct?
No,
You only saw Chris.
yes.
How are you so certain that this was Chris if you didn't see his face?
His silhouette, I've known him for a long time and I've seen him around.
How dark out was it?
A little dark.
Is there any streetlights where you live?
No,
Your whole neighborhood is dark?
Objection, Foundation.
Overruled. It's a valid question. You open the door, and it is relevant.
Let me restate the question. During this time, at 8 p.m., there was not a single streetlight turned on.
not around the area.
Was there any lights turned on at Blair's house?
No,
No further questions, Your Honor.
Is there any redirect the state would like to do?
Yeah. Mr. Bellow, are you aware of the moon?
yes,
Are you aware that the moon casts a bit of a light
Objection, leading.
This is cross-examination. This is redirect. Leading questions are permissible.
Thank
So
you.
overruled.
Thank you. Was the moon out that night?
Yes.
Is that how you were able to see Mr. Johnson?
Yes.
And when I first asked you questions, you said you saw Mr. Johnson out of breath, correct?
Yes.
So did you see his face a little bit?
Yes.
So you were able to tell, or like you were able to know it was Chris?
Yes.
After the fire department had gotten to the scene of the crime, you said you saw Chris again, correct?
Yes.
Was he wearing the same clothes?
Yes.
No further questions.
And recross.
Yes. I would like to start off by asking you what I've asked you before. Did you see his face?
Objection asked and answered.
While it has been asked, the witness did also contradict his own testimony or clarify his own testimony. So further development of that, and he clarified that in your own question, Mr. Keller. So I will allow the question, but I will remind counsel that this is trod ground and is really only usable if you're trying to develop it for impeachment purposes. So overruled. So you may ask the question.
Did you see his face?
Not the front of his face, the side.
I thought you stated before that he was walking away from you.
Yes.
Where were you standing when you saw him?
By my rose bushes.
You stated that you saw him breathing heavily, correct?
Yes.
And you live across Blair, correct?
Yes.
So, Mr. Drew, I'm trying to understand how you didn't see his face, but you saw his breathing, correct? From across the street?
I'm his neighbor. I don't live across the street.
Where do you live?
West of her.
No further questions, Your Honor.
All right. All right, the witness may step down. All right, statement calls next. Its next witness.
We're gonna call Jess Maldonado.
Right. Yep, get comfortable. You please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
All right, I'm going to need you to speak up, speak loudly, and speak clearly. And I'm going to need you to state for the record your character's name and your actual name.
Jess Maldonado and Abigail Sweeterman.
All right, Ms. Maldonado, the witness has been sworn, and sir, please state your name for the record.
Johnny Tveldy.
John
Tveldy.
Veldy?
Yeah.
Yeah. All right, so Mr. Veldy, the floor is yours to conduct your direct examination.
Your Honor, I'd like to establish this as the expert witness in regards to their fire backgrounds.
All right, so if you would like to qualify, you normally qualify through examination, so if you would like to qualify this witness, please have at it.
Okay. So what I'm about to show here is marked as Exhibit 4 for identification. Yeah, is it, Your Honor, is it all right if I stand up for this?
You've not established any foundation for any kind of expert
This was about
report.
yeah, it was about as.
You haven't established she's an expert. You need to qualify her as an expert if you want her to testify as an expert.
Okay. Can you please state your occupation?
Arson investigator for Wichita Fire Department.
How many years have you been with the Wichita Fire Department?
22.
Did you attend any schooling?
Yes, the Northwestern University Center of Public Safety.
Did you receive any degree?
Yes,
What degree was it?
an associate's degree,
When did you receive this?
1998.
What certificates, or have you received any certificates at all?
Yes,
What are they?
I have an NAFI for arson investigation and NAFI arson instructor certificate and an NAFI vehicle fire certificate.
So how long were you a firefighter at the Wichita Fire Department?
14 years
And then when did you become an arson investigator?
in 2012.
How many, or have you conducted any fire origin investigations?
Yes,
How many?
over 50.
Of those 50, how many resulted in the conviction of the criminal?
Dozens.
Have you received any honors in your work?
Yes, a community citizen award by the mayor of Wichita.
Are you a member of any associations?
Yes, International Arson Investigator Association.
Moving on to the investigation. What? So moving on. So I'd like to establish this. I'd like to establish Exhibit 4.
All right, if you'd like to establish what it is, you can ask the witness about it.
Okay. Are you familiar with this with Exhibit 4, the document?
Yeah,
You might present her with it. Use the white binder up here.
Okay. Well, Mrs. Maldonado, are you familiar with this document?
yes.
Do you know what this document is?
It's my origin of and fire report.
They're all in their single page, so you can, the whole report should be in there.
And then also, what all does this document pertain about you?
My experiences, education, and occupations.
And did you write this?
Yes.
So you showed her Exhibit 4,
Yep.
which is her CV.
Yep.
All right, so you going to do anything with that?
I'd like to put in the evidence.
You'd like to, all right, so I believe sufficient foundation has been established for that. Does the defense have an objection to admitting Exhibit 4 into evidence?
No objections.
All right, so admitted.
So now I'd like to establish Jess Maldonado as the expert witness.
You've already qualified her.
Yep.
We've already qualified her.
Okay.
Well enough to reference her report, at least.
Okay. Your Honor, I would like to show the foundation. I'd like to give a foundation exhibit.
It said use the binder for whatever exhibits you might need to you might want to show her.
Maldonado, is this look familiar to you?
Yes,
Can you identify what this?
it's the origin and cause report of the fire.
Did you repair this report?
Yes,
When?
January 28th.
Did you personally conduct the investigation that the report is based on?
Yes,
In this report, is this report a true and accurate reflection of your findings and conclusions based on what is investigated?
yes,
Is this a fair and accurate exhibit?
yes,
So you wish to move to admit Exhibit 6?
Yes.
Is there any objection from the defense to the admission of Exhibit 6?
No objections, Your Honor.
All right, Exhibit 6 is so admitted.
When were you assigned this case?
December 27th,
How long was the time between the fire and your investigation?
7 days.
How come it took you 7 days before you could do the investigation?
The structure had to be deemed safe before I could start the investigation.
So in your report, where was the origin of the fire?
The garage,
Were you able to investigate the whole house?
yes,
Were you able to see the electrical box that the Cybertruck charger was connected to?
yes, it was tripped in the middle position.
Was it properly wired?
No, it exceeded the recommended rate.
So here on Exhibit 6, on paragraph 6, is there a way you can read the first two sentences of paragraph 6?
Which paragraph is that?
Right here.
The first two sentences?
Yes, ma'am.
However, the main electrical panel in the basement was untouched and it was largely undamaged by the fire. The electrician who installed the car charger ran the wiring through the main electrical panel in the basement. And the 50 amp circuit for a 240 volt charger was in the tripped or middle position.
So off this, you were able to see the main electrical panel,
Yes,
and there was no harm or damage done to the panel.
no,
So from this, do you think the fire could have started electrically?
no, the panel would have been damaged.
Also in your report, you interviewed one of the firefighters that was on site, is that correct?
Yeah, a responding firefighter from Station 21.
What did that firefighter state they saw?
A thick, black, oily smoke coming from the garage.
So what does that thick, black, oily smoke indicate?
That there was oils and fuels burning.
What items were found in the garage?
The remains of a Cybertruck, John Deere E100 lawnmower, green plastic containers in the Cybertruck's charger.
Do you know what was in those green containers?
They appeared to store some type of fuel.
Also in your report, it is stated that there is a V-pattern scorch mark that was on the wall behind these containers, is that correct?
Yes,
Can you read off? Off on paragraph 3, where it starts with maybe please.
notably there was a V-pattern scorch mark on the wall behind these containers. A V-pattern scorch mark is indicative of presence of an accelerant and deliberately set fire.
So in your opinion, or in your expert opinion, can you please restate what that V pattern means?
That the fire was started deliberately.
Was there anything found in the V marks?
Residue of motor oil, diesel, and gasoline.
I'm going to set in your report that you obtained samples from the scene. Is this true?
Yes.
What were these samples?
S- residue left in the V marks.
And what did you do with these samples?
I sent them to the Kansas State Laboratory.
And what were the results?
That there was motor oil, diesel, and gas found in them.
And you said there were traces of diesel in the lab report, correct?
Yes.
So, paragraph 8, can you read the first 3 to 4 sentences? Which will be right.
The John Deere E100 has a gasoline engine and requires regular maintenance, including oil changes. However, it does not have a diesel engine. Given that this Tesla Cybertruck has an electric engine, there is no reason for Blair Rogers to have diesel fuel in her garage.
So based on this, should there have been any diesel in this garage?
No.
And then can you also read paragraph 7? Right, start from the laboratory all the way to
The laboratory confirmed the sample consists of burnt hydrocarbons with impurities consistent with gasoline, motor oil, and diesel fuel. Furthermore, the soot marks on the floor were indicative of the fire starting on concrete floor and then spreading to the other containers. This is inactive. The fire was set deliberately.
Okay, and then also paragraph 8, can you read where it says lay all the way down, please?
Lay people frequently use diesel fuel as a reactive accelerant due to its repulsion for burning steadily for a long time, not realizing that diesel fuel is difficult to ignite. Successful ignition would have required a long application of steady heat or the use of another accelerant such as gasoline to heat the diesel to its flash point.
Based on that, what does that mean?
That there was a mix of diesel and gasoline. Gasoline was used to light it to burn the diesel.
So does that mean the diesel could have been brought in?
Yes.
So, and then you stated that the only things in the garage were the lawnmower, the Cybertruck, and the containers filled with fuel and motor oil.
Yes.
So again, how could the diesel end up there?
There's no reason for diesel to be in there.
Was there anything else from these lab results?
Yes.
What else was in the lab results?
But there was petroleum combustion.
Okay. And then Your Honor, I'd like the witness hold out Exhibit 1.
You've done nothing to introduce any foundation as to what that is. So if you want to lay some foundation, go for it.
You know what this document is?
Yes.
What is it?
It's the layout of the house on 1196 Fall Creek Road.
Are you familiar with this document?
Yes.
Okay. So, for the jury, can you hold this out? And can you point out where the garage is of this house?
The garage is right here.
Would you like it a little bigger?
Yes, please, that would be great.
You want to angle that TV towards the jury? Can the jury see that? Can the jury see that? All right.
Okay, Ms. Maldonado, I'd like to direct your attention to. Are you able to see? I can try again.
Is that sufficient? Is the jury able to see that?
So the garage is right here, correct?
Yes.
Where was the Cybertruck roughly parked?
In the north bay closest to the house.
So right here.
Yes.
Where was the lawnmower located?
In the southeast corner.
So that would be what, right here?
Mhm.
Where were the green containers located?
Between the Cybertruck and the wall closest to the house.
So this wall right here.
Yes.
And then where were the V scorch marks?
On the lower portion of the concrete wall.
Can you, where at?
On the north side of the Cybertruck.
So in this area right here?
Mm-hmm.
Okay.
Does council have further use for this particular exhibit blown up at this time?
Oh,
That's why I ask at this time.
yeah,
You'd like it left up?
yes.
All right.
And then one other thing, sorry,
Are you going to seek to admit the exhibit as you laid foundation and used it?
yeah, please.
Any objection to the admission of the exhibit?
No objections, Your Honor.
All right, so admitted.
Last thing, where was the electrical, or where was the charger for the Cybertruck located?
On the west wall in front of the Cybertruck.
So roughly in this area.
Yes.
And then also, where was the main electric panel located?
In the basement.
Where do you enter the basement?
Going right of the kitchen. There's a staircase going down.
Right here.
Yes.
So following your investigation, would you say anything electrical could have started this fire?
No.
Based on this, what is your expert opinion on this matter?
That the fire was started deliberately.
No further questions, Your Honor.
All right, thank you. For cross-examination, sir, please state your name for the record.
Idon Marquez.
A little louder, sir.
Idon Marquez.
Don. All right, so Mr. Marquez, do you require usage of the blown up Exhibit A? Exhibit 1, rather?
Yeah, I'd like to keep it up there.
All right. So then, sir, floor is yours for cross-examination.
Alrighty, so. What's her name? Miss Maldonado. I'd like to go back to a comment you made about the wiring in the house.
Okay.
When you inspected the wiring, you said that there was something wrong with it. What was wrong with it?
The wiring was stripped of the copper.
Why was it stripped from the copper?
The police were unable to secure the crime scene.
How long was the crime scene left unsecure?
7 days.
7 days? Do you think that the crime scene being tampered with could have harmed your investigation of the fire?
No,
Why not?
because the electrical panel was untouched. Nothing was messed with it.
Nothing was messed with the electrical panel in the basement,
Yes.
but you said that the flip was switched.
Yes, but it could have been switched when the fire started.
When the fire started?
Mhm.
Can the fire cause an electrical malfunction in there?
Yes.
In your origin and, oh, I'm sorry, getting a little ahead of myself. I'd like some clarification because when you were getting questioned, you mentioned that you found scorch marks behind the green containers and that shows that it started there, but you also mentioned that you found soot marks on the concrete and that shows where it started?
The north wall is half concrete and half drywall. The V marks were on the lower part of the wall.
The lower part?
Yes.
Okay. But you mentioned it being on the ground. Does that just mean did you just mean the lower part of the wall?
Yes.
Okay. You mentioned seeing smoke from the garage and deducing that that was because of diesel fuels and or other fuels being lit.
The responding firefighters saw it. Yes.
But you mentioned in your origin and cause report that could also just be caused by insulation.
Yes.
What made you determine that it was from gasoline and diesel then?
From other residues found in the garage.
From the residues? Okay. You mentioned that you found oil, gas, and diesel in the garage,
Yes.
and you say that Blair Rogers had no reason to have it there?
Yes.
What made you conclude that she had no reason to have it there?
She had no other vehicle that would use diesel fuel.
What vehicles did she have?
From my report and what she stated, just the Cybertruck and the lawnmower.
Okay. So you're not aware that she has another vehicle?
No.
So when you're looking at the layout of the house, you said, where was the charger?
Along the west wall in front of where the Cybertruck would park.
West wall in front, so I need to go up there and point.
Mhm.
May I stand?
Yes.
Okay. Testing, testing. Is it working?
Look at the top. Does it say mute? The top of the unit.
Don't see anything.
Bring it up here. Oh. It should work.
Testing, testing.
I think I know what the problem is. Yes, so just tap the top. Tap the power button.
Testing, testing. Okay. So on this, would the charger have been right here?
No, along the west wall.
The west wall.
North
over
is
here.
north is up, west is to your left, right is east, and south is down.
So it would have been on this wall then.
Yes.
And the Cybertruck was over here?
Yeah, parked in that bay.
Okay. So how did you conclude that the fire wasn't started by the Tesla truck and was instead caused by the accelerants?
There was, along the V mark, you could see the trail that led to the green containers that further accelerated the fire.
There was a trail that was leading towards the green containers?
Yes.
Can you point out where this trail was?
Along the north wall, after the lower half, there was a trail of residue leading to the green containers.
So there would have been a trail leading from here all the way over there?
No, the V marks were right there.
Right here?
Yes.
So where was the trail? Did it go over here?
No, the green containers were along that wall as well.
Can you point it out on your own copy of it so I can have a...
Yeah, so the V marks were right here as well as the green containers.
And then you said there was scorch marks leading towards it?
Yes.
Where did these scorch marks go?
What do you mean?
So you say there was scorch marks leading towards the green containers?
Yes. They went from the V to the green containers.
So it's all just along the north wall?
Yes.
Okay. So, you mentioned that diesel is very hard to ignite, correct?
Yes.
And that it was most likely caused, well, no, let me rephrase this. What do you believe caused this diesel to ignite?
Using gasoline as a flashpoint.
gasoline as an accelerant to
Yeah.
cause it to light on fire.
Yes.
And you don't believe that diesel should have been there?
No.
And that's because you don't know about her other vehicles. Based off the vehicles you saw there, you saw no reason for there to be diesel?
Yes, and of her report.
Other than this, you say that the copper was stripped?
Yes.
No copper, and you don't believe that it hindered your investigation at all?
No.
No further questions.
All right, redirect. If any, Mr.
Yep.
Keller.
Who?
You, sir. I'm sorry. I'm sorry, Mr. Tavalda.
No, you're good.
Baldy, sorry.
So back on the back on the electrical panel, let's say it did start say this fire did start electrically. Would the main panel be damaged?
Yes.
But was it damaged?
No.
So that would indicate that it was not electrical fire.
Yes.
And you said there was other residue found in the garage, correct?
Yes.
Other than oil and gas?
Yes.
What was the other residue?
Diesel.
And no further questions, Your Honor.
Recross?
Yes.
Floor's yours, sir.
So you say that that if the fire was an electric fire, it would have harmed the main circuit in the basement?
Yes.
Could the fire have caused an electrical surge?
Yes.
So is it possible that the fire started from the garage? So what you think currently is that the fire started in the garage and then just spread?
Yes.
And then what caused it to trip?
The fire reaching it.
But there was no scorch marks on the panel?
No.
So what do you mean by the fire reaching it?
The panel for the garage was located in the basement as well. Neither were harmed in the fire.
So what? I'm having some trouble understanding. So if the fire reaching it would have caused it to trip, but the fire didn't reach it.
It didn't reach the panel, but it reached where the charger was located in
Where
the
the
garage.
charger was located?
Yes.
Okay. No further questions.
All right, the witness may step down. Does the state have any further evidence it wishes to present at this time?
No, Your Honor.
All right, in that case, then we shall take a 10-minute recess. Well, we'll call it 12, so we will get back together at 9:40. I would ask that the jury sequester itself in the jury room. There's a bathroom in there. Do not talk to the jury, folks. Let's talk amongst yourselves. The bathroom out there. Jury rooms out. I will take you there myself. You got it? All right. Thank you to our bailiff. And we will be back in 10-ish minutes.
So I can cross it out or. Yeah. But I'm using this opportunity to bring the high school grade. Well, it's true.
They let go through. Make sure he doesn't even.
When I'm up there, I'm like, so. I get my. You don't hear me the whole time? Never mind. That's what I should do. Best I could do.
Someone gonna get him. No, they won't choose you. They'll choose you. I know.
Yeah, that's what I thought. Which is not fun, but.
Yeah, but I'm gonna put this in front of you. He knows this is gonna happen. I don't care. Nobody else is done it.
He might just tell you to bring it up from the binder though.
He said it only had the exhibits in it. It didn't have
No, the binder
statements.
has the statements.
Oh, it does?
Yeah.
Ours does, theirs doesn't.
Theirs doesn't, it only has exhibits.
Yeah, go for it. Go for it. So do hurry up.
What, how much time do we have? Okay.
You need the clerk's office's number,
No.
or if she can, or if she knows how to text for Zelda, that'll.
You have to load it up.
Picture my copy, Richard Orwell. Yeah.
We can. As long as it's in.
Well, maybe, whether it's relevant or admissible is a good question. But whether it's relevant is a good question. That's, I will explain, I will be happy to explain my master plan behind that.
Okay.
So yes, it is those are part of the problem. Those facts are part of the problem, and you may bring them up if you so choose.
Okay.
Or at least attempt to bring them up if you so choose. All right, as it is now 9:40. Is everybody back? Dalen, do you need another minute? Right. So, counsel, if next witness, next examiner for the defense would come on down? We can do a jury trial without the jury, can't we?
Good call.
It's a bench trial from here on out. Bring it on. Yeah, a minor inconvenience, barely an inconvenience.
Especially right now.
Yeah. Hey, are you using any evidence that you're gonna submit?
Yeah,
Okay.
but we have a white folder. don't we?
Yeah, but you can also grab it from here. Okay.
Well.
Do you need any of this? Do you need
What
note-
is it?
Do you need a notebook to write anything down for like recross or anything?
Yeah.
Yeah, like it's right here. Yep. Somebody told me. I don't know.
So what everyone's saying is that once this is done, I should go to the live stream and I should clip my trying to get the jury trial back underway, having forgotten that we didn't have a jury. That'll be a highlight of today. All right. Now then, is the state ready? We have our jury back. Not that we need them for a jury trial. Hint, hint, wink, wink, nudge, nudge. Still ready to make us a bench trial if we need to. Is the state ready to proceed at this time?
Yes, Your Honor.
Is the defense willing to proceed at this time?
Yes.
All right. As the state has finished its presentation of its case in chief, we now move on to the defense's case in chief. Would the defense like to call its first witness?
I would like to call Chris Johnson to the stand.
Please state your name for the record, sir.
Dalen Anthony Perez.
All right. Mr. Rogers, if you please approach. Oh my.
Yeah, not good thought.
I mean, if you're familiar with certain facts in this case, it would be very on message. Would you please raise your hand, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
Please state both your character's name and your actual name for the record.
Chris Johnson has Molina.
All right, Mr. Johnson. The witness has been sworn, and I yield to the floor to the defense to conduct its direct examination.
May you please state your occupation?
Current student at Camden University.
Do you know Blair Rogers?
Yes.
Is Blair Rogers the one that testified on the prosecution's behalf?
Yes.
How long have you known Blair Rogers?
Since middle school.
Do you consider Blair Rogers a friend?
Yes.
Because you have known Blair for that long, would you say that she is a good judge of character?
Yes.
Were you present when Mr. Rogers testified earlier this morning?
Yes.
How did Miss Rogers describe you?
As a bad person.
Do you agree with her characterization of you?
No,
Why would she say such things about you?
because she's upset.
Is one of the reasons your relationship with Miss Rogers is fraying because of the schools each of you were admitted into?
Yes,
What college did you want to get into?
Camden.
Did you tell others you wanted to get into Camden?
Yes,
Did your parents want you to go into another school?
yes.
What school was that?
Oxwell University.
Did you tell others you wanted to get into Oxwell?
No,
However, in your witness statement, it does say that you told Blair, did you not?
yes.
Was Blair the only one that you told about wanting to get into Oxwell?
Yes,
Why did you tell her you wanted to get into Oxwell?
because she would want to go to that college as well.
So you knew that if you were to apply to Oxwell, she would also apply.
Yes,
Moving on from that, my apologies. Okay. Sorry, I will be continuing. Do you have any unhappiness for Blair since she got into Oxwell?
no,
Any jealousy?
no,
Any desire for revenge?
no, sir.
Did you have plans for the night of December 20th?
Yes.
What were those plans?
We were gonna go to Blair's house first, and then after that, me and my girlfriend Riley Goldman, were going to movie marathon.
What movie marathon was being hosted?
Harry Potter one
What time were you planning to go see the movies?
at 4.
And on what day exactly?
December 20th.
How far was the movie theater from Blair's house?
About a mile.
So you and Miss Goldman went to the house party, correct?
Yes,
When was that?
around 1.
You got to the movie marathon in time for the first movie to start.
Yes,
Did you stay to watch the entire movie marathon?
yes, I did.
What did you do after the end of the movie marathon?
I went home.
So you watched 8 two-hour movies back to back.
That is correct.
Did you leave the theater that the film was being shown in?
No.
Did you get hungry?
Yes,
Did you use the restroom?
yes.
How'd you handle that?
We had a time schedule for that.
Just to confirm for the record, you did not return to Blair's house that evening.
No, I did not.
Would you please read the terms and conditions on that ticket?
Yeah.
You've laid no foundation for what he's even looking at, counsel.
My apologies. What he is currently looking at is
That you don't proffer that to the court. He has no basis to know what the heck that is. He can't testify about it.
I would like to submit into evidence Exhibit 7,
Which you've laid no foundation for.
movie
wit-
tickets.
The witness has not stated that he has any familiarity with what Exhibit 7 is. Would you like an opportunity to try to lay some foundation, Mr. Perez?
Yes.
The floor is yours to lay that foundation.
Do you recognize those tickets?
Yes, I do.
Are they yours?
Yes,
How do you know that they're yours?
it says my name.
May you please read the terms and conditions of your ticket?
Yes, I can. Terms and condition. Tickets cannot be exchanged and are non-transferable. No ticket, no entry, no re-entry. Lost or damaged tickets will not be redeemed.
So I would now like to submit into evidence Exhibit 7, the movie tickets.
Is there any objection to
Yes.
basis?
He stated what the document was before submitting or before Chris stated what the
Which
exhibit
is-
was.
That does not mean that the defendant does not have any personal knowledge of it. The defendant has testified that those are his tickets that he acquired.
Yeah.
Am I incorrect in my understanding of the testimony that's been offered?
No.
So there is a personal basis for it. So there's a foundation for it.
Yeah.
It has been identified. So do you have a basis for the objection other than that?
No, Your Honor.
Mr. Perez did not lay foundation in the best way possible?
Yeah, no, Your Honor. No, nothing else.
Oh, so are you going to withdraw the objection then?
Yes.
All right, the objections are withdrawn. So admitted without objection. So Exhibit 7 is admitted without objection. Floor is yours still, Mr. Perez?
All right. Is the reason you didn't leave the movie theater because you wouldn't be able to get back in?
That is correct.
I would like to move on from that back to the party. Something else happened at the party, did it not?
Yes,
Did you receive a phone call?
yes, I did.
Who was that phone call from?
From the vet.
What was the call about?
About a stray dog going into the vet and asked if I was interested in one.
So you were considering adopting a dog.
Yes,
So you're getting over Husky then?
not quite.
What did you tell the vet?
I told them I was not ready for a dog yet. I was still sad over my dog passing away.
So you're taking a call at a party about a very emotional subject out in the open?
No.
Did you go somewhere quiet to take the call?
Yes.
Where did you step out to?
Into the laundry room.
Do you know where the laundry room is relative to the garage in Blair's house?
Yes.
And you were present for the state's expert witness who claimed that the fire started in the garage.
Yes.
Did you go into the garage while taking the call?
No.
Did you start a fire while taking the call?
No.
Did you touch anything at all in the laundry room?
I did not.
Did you do anything nefarious while taking the call?
No.
Did you do anything other than take the call?
No.
And that was because you were dealing with some emotions, were you not?
Yes.
Because even though Husky is gone, it is still difficult for you.
That is right.
When the call ended, what did you do?
I went back outside.
Do you know what a John Deere E100 is?
I do not.
Could you identify one if I gave you a picture?
No, sir.
Was there a John Deere E100 in Blair's garage?
How would I know if I wasn't in it?
Would you have known that if it had not been testified today?
No.
What did you and Miss Goldman do after you left the laundry room?
We said bye to everybody and went to our local theater.
When were you made aware that Blair Rogers' house had burned down?
The Tuesday morning.
No further questions.
Before I turn this over for cross, for clarification purposes, is Husky the dog that Ms. Rogers testified that was run over?
Yes, Your Honor.
Thank you.
Yes, sir.
All right, I will yield the floor to Cross. And sir, please state your name for the record.
Eben Yuri.
Evan, all right. All right, Mr. Yuri, the floor is yours to conduct your cross-examination.
May I please stand?
You, of course,
Okay.
but make sure you've got the mic. And you're already wired up. Excellent.
Okay. So, Mr. Johnson, do you have any other names or nicknames that you go by?
They call me Sparky Boy.
May you please explain to the court how you obtained said name?
Well, me and my friends used to do jokes, and some people say I took it too far, but we never thought we took it that far.
Okay. The party occurred on December 20th, correct?
Yes, sir.
Do you know exactly when Blair hit your dog? Like a time frame?
Uh,
How long before the party?
I don't know.
Okay. Who was the one that asked Blair to have the party?
Me.
Okay. Why would you want to have the party at Blair's house specifically?
She had a pool.
Of the time of year, why would you want to have a pool party in December? Isn't that a little strange?
It's a nice day.
Fair enough.
Objection?
Basis?
Relevance? I feel
I will allow it. The state might have been going somewhere with it, but it would appear that that somewhere has ran into a dead end.
Yes.
So I don't think it's irrelevant. I think it could go to credibility, as the state does raise an interesting question that could have had an interesting answer. So that is why I will allow it. So objection is overruled.
Can you please explain what happened before you left the party again?
I had a call from the vet.
Okay. And you said you took the call in the laundry room.
That is correct.
Did you move anywhere else while taking that call?
No, I did not.
Can I please present him his statement to read?
You may.
Okay. Starting on line, here you can hold it. On line 113 to 115 in the highlighted, can you please read?
I can. There were quite a few people at the party, and I was glad to see all of us together after a long time. Right before Riley and I left, I got a call on my cell phone from the vet, but couldn't hear over the loud noise. I stepped into the laundry room trying to get some quiet space. It was still too loud, so I went outside.
That's it. All right. So you did indeed move somewhere else then while taking the call? Other than the laundry room?
I just went from the laundry room back outside.
Okay. Can we pull up Exhibit 1?
I can.
Okay.
Give me a moment.
All right. So you took your call in the laundry room, which is right here.
Yep.
And then
When you moved outside during the call, you went through the laundry room door, correct? You did not enter the garage.
Yes, sir, that is correct.
So you walked along this area right here then?
Yes.
Okay. I would like to point out there is a window right here that has a clear view of the Cybertruck. And I just want to, did seeing that remind you of your dog?
Really didn't think much of it.
Okay. Well, you and Blair live in the same neighborhood, correct?
Yes.
And you stated earlier that Blair's house is around a mile from the theater.
Yep.
While at the theater, did you hear any sirens?
No.
Objection.
Basis.
Relevance.
Counsel, what is your basis for soliciting to ask that question?
If he was able to hear it, then maybe it would have.
Going to credibility, you're using this to impeach and going to credibility?
Yes.
I will give you some leash in your questioning.
Okay.
So I will overrule it for the time being. So it is relevant for the moment. That doesn't mean it will always remain relevant.
Yep. Thank you. All right. So may you please answer the question?
Yes. Can you repeat it, please?
While at the theater, did you hear any sirens?
I did not.
The theater is only a mile away. How would have you not heard anything?
It was pretty loud in there.
Okay. When you returned home later that night, you and Blair live in the neighborhood, same neighborhood. How would you have not noticed the scene or smoke or anything of that sort?
I didn't go that way. I went a different route.
But you live in the same vicinity as Blair, correct?
Yeah.
Okay. And on your way home, you didn't see any fire, smell any smoke?
I did not.
Okay. I'd like to make you do some more reading for me. Can you please read from 119 to 123 in the
Right now.
highlighted?
Excuse me?
119 to 123.
Right after I finished talking with the van, went back inside Raleigh, and I left for the theater. We said goodbye to people, though it was all pretty fast, and I didn't know if Blair was around. When we were saying our goodbyes, Monday night after the movie marathon, I went home and classed him to bed. It wasn't until Tuesday morning that I found out about the fire.
Can you please tell me what's missing?
What's missing?
Why is there an 8-hour gap in your statement?
Let me go back to it.
From 4 p.m. on the day of the fire to the next morning, your statement is lacking.
Because we were still watching the movie marathon. Like, you just.
And you didn't want to describe that in your statement in any way?
No.
Are you sure you actually attended the movies?
Yes.
Because according to your statement, it doesn't look like it.
I don't think you need detail by detail.
Okay. There will be no further questions, Your Honor.
Sounds good.
Right. Is there any redirect counsel would like to do?
Yes.
Do you have need for exhibit 1?
Yes.
All right, so I will keep it up then. So the floor is yours, Mr. Perez, for your redirect.
So, given that in your statement you said that you left outside, would one note that the laundry room has a door leading outside?
Mm-hmm.
So there would be no need to enter the garage, correct?
That is correct.
So, out of curiosity, you do live on a two-way street, correct?
Yes.
So it is possible that you could have entered the street that you live on through the other side of the street where Blair's house wouldn't be directly visible.
Yes.
And just to note that you are aware that in Riley Goldman's statement, she did say that you were present with her at the movies.
Yes.
No further questions.
Any recross?
Yes, Your Honor.
Floor's yours, sir.
So you did state earlier that you live in a close proximity to Blair.
Yeah.
And that means the theater is also around a mile away from your home, correct?
Yeah.
So if you were to go an alternate route, you would still have to go through that same area, correct?
Not if it's a two-way. You can go through the other side.
But to go through the other side, you'd have to go all the way around through it, go back to the other way.
Objection?
The witness has already answered the question. On what is the basis of the objection?
I believe that it is confusing.
Well, the witness does not understand the question. He is free to state that he does not understand the question. So I will overrule the objection.
Okay.
Because the witness has already answered.
You were also earlier stated when I was asking you which door you exited out of the laundry room, you did go out this door. Is that correct?
You point to it?
Right here, earlier you stated you went this way?
Yeah.
So there would be no reason for you to go out a different way then. You went out through this hallway alongside the garage.
I didn't go inside the garage at all, though.
Objection? Speculation?
As to what? As to what aspect of that?
I believe that he is implying that my client went one direction when he could have gone the other, and that would be considered speculation.
He previously stated that he went that way though.
He said he went outside.
Yeah, and I asked him if he went through that door, in which he agreed.
Does counsel want to attempt to re-ask the question in a way that addresses the objection? You want to try mulligan asking the question?
Just ask the question again? Or what do you
Try to do it with the mind of what the objection has been. Would you like a chance to rephrase?
Sure.
All right. Floor is yours.
So, earlier within the statement, you stated that when I asked you, you went through the west door. Correct.
To go outside?
Yes. You did not go through any other door in the laundry room besides entering.
Mr. Rogers, Mr. Johnson, rather, would you like a copy of Exhibit 1 so that you can look at it a little more closely?
Yes, please. Okay. So can you repeat your question, please?
I was just more so asking you to please restate the way you.
Yeah, I entered through the door.
Yep.
Just into the laundry room. And came back out the same way I entered.
And then which, earlier you stated you went through this door though, instead.
No, you pointed at the door that we were just talking about.
Yeah, this door.
Well, I walked out and in.
Yeah, you walked out of that door?
Yeah.
Okay, no further question.
All right. All right, that concludes recross, so the witness may stand down. All right, would the defense like to call its next witness, and would someone like to come return the exhibit binder to the front of the bench? Thank you. Right, please state your name for the record, ma'am.
Brisa Montez.
Right, Ms. Montez, if you would like to call your next witness.
I'd like to call Riley Goldman to the stand, please.
Please raise your right hand, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
You may lower your right hand. Please state both your character's name and your actual name for the record, please.
Riley Goldman and Adeline Riley.
All right. All
Could
right,
you-
the witness has been sworn. She's all yours.
Okay. Could you please state your occupation?
I'm a current student at Greendale Community College, and I do drywalling with my mother.
What are you currently studying?
Film.
And what are you here for today?
To testify on behalf of Chris Johnson.
How did you meet Chris Johnson?
We were in the same school for a long time, but it wasn't until sophomore year in Miss Shallow's psychology class that our desks were next to each other. And I asked him if he wanted to get some caramels, to which he said yes.
So could you say you have known Chris Johnson for a long time?
Yes.
When did you and Mr. Johnson begin dating?
At the beginning of 2024.
I'd like to shift to the date of December 20th, 2024. Is it true you accompanied Chris Johnson to Blair Rogers' pool party on December 20th, 2024?
Yes.
What time did you and Mr. Johnson arrive at the pool party?
Around 1 p.m.
During the party, were you and Mr. Johnson together for most of the time?
Yes, for most of the time until I was in a disagreement with one of Blair Rogers' friends over whether George Lucas had made a good movie in our lifetime or not. And then I met up with him afterwards.
After that interaction, where did you and Mr. Johnson leave to?
The Harry Potter movie marathon.
How far is the movie theater from Blair Rogers' house?
About 1 mile.
How did you and Mr. Johnson get there?
We Ubered, changing into Slytherin and Ravenclaw robes on the way.
And what time did you and Mr. Johnson arrive at the movie theater?
Around 4:00 p.m.
I'm going to be using the movie tickets again.
So you want to use Exhibit 7, so
Yes, please.
to present them to the witness, that is your prerogative.
Miss Goldman, could you please read to the court what those tickets say again?
Terms and conditions. Tickets cannot be exchanged and are non-transferable. No ticket, no entry. No re-entry. Lost or damaged tickets will not be redeemed. And present this ticket upon entry.
What are the two exits from the movie theater?
The fire exit, which supposedly had an alarm, or the front exit by the concessions.
Would you say you or Mr. Johnson left the theater?
No.
Where were your seats located at?
In the farthest back row in the middle.
Did you or Mr. Johnson take bathroom breaks or get up for food?
Yes.
Would you say he was with you for the entirety of the movie marathon?
Yes.
At 9:14 p.m., where were you?
I was asleep.
At what time did you fall asleep?
9:00 p.m.
Was Chris Johnson still at your side before you fell asleep?
Yes.
Waking up, Chris Johnson was still there, correct?
Yes.
What movie was on when you woke up?
Prisoner of Azkaban.
And what time did this movie start?
9:53 p.m.
Did you leave after the movie marathon?
Yes.
When did you receive word of the fire that started at Blair's house?
The next morning.
So in conclusion, can you confirm that Chris Johnson did not commit the accused crimes he is being charged with?
Yes.
No more further questions, Your Honor.
Right, cross-examination from the state. And please state your name for the record, ma'am.
Yoselin Avila.
Right, Ms. Avila, if you have any cross, the floor is yours.
At what time did you leave the party?
Around 4:00 p.m.
And what time did you get to the movie theater?
Before 4:00 p.m.
But if you left at the party at 4, how did you get there?
I said around 4:00.
Do you get along with Blair's friends?
No.
Why?
I just mutual friends with Blair, not anything special. I don't know her other friends.
You stated you fell asleep during the movie marathon. Is that right?
Yes.
How long were you asleep for?
About 40 minutes.
Mm, do you know for sure that there was an alarm on the fire exit?
To my knowledge, yes.
Was it completely dark in the movie theater?
Yes.
Are you sure it wasn't easy for someone to sneak out or sneak in?
Yes.
So it could have been easy to sneak back in.
No.
Can I please stand up?
But of course, if you're mic'd up, you don't need to ask my permission to get up to examine the witness.
I'm gonna have you read your statement. Can you read line 96 through 101? Please.
96 through 101.
Yep.
And yes, I fell asleep early for the back half of Chamber of Secrets and the beginning of Prisoner of Azkaban. But can you blame me? I wanted to make sure I was awake to see the ending of the marathon. The whole 8-movie marathon is 19 plus hours long. You couldn't expect me to stay awake for the whole thing. From my recollection, Chris had their sleep schedule planned out in advance. They'd catch some winks during the Order of Phoenix and then with me during Deadly Hollows Part 1.
So isn't that longer than 40 minutes?
What?
You falling asleep.
Can you please restate the question?
Objection, confusion.
Please, well, again, if the witness does not understand the question, the witness needs to state as much, because if you don't understand, you don't understand. So, would take it from the top, ma'am.
Did you state, can you please restate, for how long did you fall asleep for?
40 minutes.
And isn't the Chamber of Secrets and the beginning of Prisoner Azkaban about around 2 hours long? And you fell asleep?
I fell asleep for the back half of Chamber of Secrets and the beginning of Prisoner of Azkaban.
If I may, to perhaps break the impasse, and approximately how long was that?
Around 40 minutes.
Not how long you fell asleep, how long was the runtime of the back half of Chamber of Secrets and the stretch before the start of Prisoner of Azkaban?
Probably about an hour.
So you could have slept for 2 hours long instead of 40 minutes.
No.
Were you with Chris? Were you with Chris the whole time at the party?
Yes, until I was in an argument with one of Blair's friends.
How long did it take for you to take to the movie theater?
Approximately 30 minutes.
But the house is only a mile from the movie theater. You could have walked or run.
There was traffic and we were in the Uber.
But shouldn't it be faster? 30 minutes for a mile?
As I stated before, there was traffic.
No further questions.
Right, redirect.
You fell asleep for 40 minutes, correct?
Yes, around that time, around that amount of time.
And Chris Johnson was there when you fell asleep and when you woke up?
Yes.
Is it true you were wearing costumes at the movie theater?
Yes, I was wearing Ravenclaw. Chris was wearing Slytherin.
Is it true you changed in the back of the Uber?
Yes.
So with the house, Blair Rogers' house being a mile away, would it take 30 minutes around there to arrive there with costumes on?
Yes.
No more questions, Your Honor.
Right, any recross?
Yes, Your Honor. In your own statement, it says, who knows if they kept that policy? That's not certain, that's doubt, correct?
Yes.
So the whole point of your defense is that Chris couldn't have left?
Yes.
But you stated that they might not uphold the policy.
Yes.
So it's possible he could have left or he could have sneaked in.
Yes, but us diehards follow the rules.
But you also stated, I may have been asleep when they returned. That implies you actually don't know where Chris was at while you were asleep.
Correct.
So Chris could have left the movie to come back with you, and knowing you're right.
Can you please restate the question?
So Chris could have left the movie and then came back when you were awake.
No.
I'm gonna have you read this statement. Start right there where it's marked.
Okay, and then read.
To the highlighted part,
What is the line? What is the line?
line 57.
Thank you.
And not even peak Sandler like Billy Madison or Waterboy. No, we're talking grown-ups like Jack and Jill. It was truly and deeply painful. Eventually, I just couldn't take it anymore. Little by little, I took the Sandler movies with me when I left work, usually one or two a night, to avoid detection. Once I got home, I'd open each case, crack the Adam Sandler DVD in half, and replace it with a masterpiece, a Coppola, Scorsese, Kubrick, Bigelow, or DuVernay. I'd take these cases back, upgrade with my superior movies, and the next time someone planned to watch Pixels, well, they were in for a treat. Was it dishonest to the customer? Maybe in a literal sense, but the big picture, they were getting an education. Also, I didn't even profit. I loaned them my own DVDs. But as any crime film will teach you, it's only a matter of time before you get caught. Turns out the legal system calls the destruction of $749 worth of DVDs theft rather than intellectual charity. And long story short, I was found guilty in that court.
So don't you think that proves that you don't follow the rules if you broke into them?
I was a sophomore whenever I committed that crime. I'm a changed person now.
But you still committed it.
Yes, I made a mistake.
No further questions, Your Honor.
As defense counsel has taken as the state's taken liberties with the scope, I will allow redirect to have the final word given the scope was exceeded for recross. So if the defense wants redirect, floor is yours.
I'll go ahead and redirect. Redirect.
Just remember scope of examination. I would be greatly I have no interest in doing recross.
Miss Goldman, have you done any other crimes?
No.
And this crime happened 4 years ago, correct?
Yes.
You were a minor at the time of the crime, correct?
Yes.
What did you learn from this experience?
I learned from my mistakes and I became a changed person not to do that again.
No further questions, Your Honor.
All right, I have two questions. As far as the scope of this offense from the witness statement itself, he did it at least 5 times. There's a reference to a Coppola, Scorsese, Kubrick, Bigelow, and Duvernay. So there were at least 5 times you did it, even if it was only amalgamated into a single criminal offense, correct?
Yes.
All right, and as you're the sort of person who's a cinema buff, did hand shoot first? As you are the sort who likes to argue about Lucasfilms.
Can you restate that question?
Did hand shoot first?
No.
Correct answer. Witness may stand down. Actually, yes, yes, put that back in the binder. I can't even remember my Star Wars movies correctly. That's the wrong answer. That's the wrong answer. That's the special edition talking. I've been corrupted. All right. Defense like to call its next witness. Right. Please state your name for the record, sir.
My name is Colin Green.
All right.
I would like to call up Pat Kendrick to take the stand.
Ms. Kindred, if you'd like to please approach. Have a seat. Get yourself comfortable. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right, please state both your character's name and your real name for the record.
Pat Kendrick and Jackenzie Worsley.
All right, the witness has been sworn, so Mr. Green, she's all yours.
I would like to enter my Exhibit 11 to establish my witness as an expert.
You need to qualify your witness before you can, you need to qualify your witness, so that's done through testimony.
Ms. Pat Kendrick, please tell the court what is it you do?
I'm an expert electrician. I determine the cause and origin of fires.
Anything else?
No.
Does the defense require that the bench qualify this witness?
Yes.
Is there a reason why the defense cannot qualify this witness?
I'm going to enter Exhibit 11.
Not if you don't qualify the witness.
I'd like to prove that my client is a expert, Your Honor.
Your client is sitting next to you. Ms. Kindred, you're an electrician by trade, is that correct?
Yes.
Do you have any formal training?
Yes.
What is your formal training?
I was 12 years at 12 years of schooling and 10 years as a teacher for like
So where did you go to school?
University of Texas.
For how long?
20 years.
So you went to school for 20 years.
Went to school for 12, but I was at that same school for another 10 teaching.
Okay, so what degrees did you obtain at the University of Texas?
I have an MS in electrical engineering and a BS in electrical engineering.
All right, and so then it took you 12 years to get your MS, and then you were then a teacher at Texas for another 10 years since then?
Yes.
Is that what your current occupation is?
Yes.
Do you testify as an expert witness in criminal proceedings?
Yes.
Not criminal, in court proceedings, all right. Do you have any professional awards?
Like
Have you won any
degree?
professional awards?
I'm not sure what you mean.
Have you accomplished any great things in the profession that any professional organizations have seen fit to award you recognition for?
Yes.
And what was that?
Can't name them off the top of my head.
Are you a member of any professional organizations?
Yes.
All right, if the defense would like to produce the exhibit for the witness, use the binder. Use the binder. Ma'am, is the document you are holding, what is the document you are holding?
It is showing my experience, education, and my skills and certifications.
So it is your resume?
Yes.
Did you prepare it?
Yes.
Right. And it is true and accurate to the best of your knowledge?
To the best of my knowledge, yes.
For the defense's benefit, that's how you qualify a witness, to be an expert. And also add some foundation for your exhibit.
Thank you.
Let the record reflect this was done primarily because in a criminal proceeding, every accommodation is to be provided to the defense because the defendant is presumed innocent until the state has proved his guilt beyond a reasonable doubt based upon a finding of the jury, not me. And I'm not having this matter come back to me on appeal because of counsel's incompetence. So, having made my point, I will yield the floor back to the defense in order to continue its direct examination. So with one final note, the defense wishes to admit Exhibit 11.
Ms. Kendrick, have you ever?
But answer the question.
Yes.
Any objection from the state?
No, Your Honor.
All right. So admitted without objection. Now, the floor is yours for direct examination.
Ms. Kendrick, have you ever testified as an expert in electrical engineering and cause of origin in both state and federal courts?
Yes.
Ms. Kendrick, why are you at this court today?
I'm here on behalf of Chris Johnson.
As a part of your investigation, Ms. Kendrick, I assume you have had time to look over the evidence provided.
Yes.
Ms. Kendrick, to the best of your knowledge and experience, would you have hired Electric Eel?
Not for a job this big.
There's no foundation. The jury will disregard the answer. There's no foundation as to what electric eel is or why one would hire a fish to perform electrical work.
Electric Eel is the company.
You don't proffer that to the court. Because a proffer is the attorneys are not allowed to testify. That is the job of the witnesses.
Ms. Kendrick, can you please tell me what Electric Eel is?
A company that, sorry, it's a company that helps you figure out wiring stuff.
And what is your basis for that knowledge, ma'am?
I don't have one.
So that was speculation.
Yes.
The jury will strike the witness's response. Pay it no mind. Ignore that it happened.
What did you find upon the scene?
I found that the scene wasn't closed for many unseen days and copper wiring had been removed.
Anything else?
I found V-shaped patterns along the wall, the north wall, close to the concrete floor, and V-shaped burn marks close to the front of the Tesla Cybertruck, as well as the remainders of the Tesla Cybertruck and its battery.
In this instance, and based on your experience, would you say Ms. Maldonado lacks formal significant scientific training?
Yes.
Ms. Kendrick, based on the evidence you have seen and your experience, could you please state your opinion to the courts?
In my opinion, the lithium battery of the Cybertruck is what started the fire because it sent out a fault code showing something was wrong and that it overheated.
Were you able to personally inspect the home's wiring?
Yes.
And that is?
It showed that something was wrong, like if somebody that did not know what they were doing was doing the wiring.
Ms. Kendrick, were you able to conduct a bench download?
I was.
Could you please explain what a bench download is for the courts, please?
A bench download is an error code that got sent out from the Tesla Cybertruck and its battery showing that something was wrong.
Before I let you go, Ms. Kendrick, please tell the courts your final opinion according to your professional engineering degree?
In my professional opinion, I think that this was no sign of arson. This was a overheated circuit that happened in the battery. And I think that Jess Maldonado's report should be stricken from the record because her evidence was tampered with, so she cannot conduct a full understanding of what happened.
Thank you, Ms. Kendrick. No further questioning, Your Honor.
All right, sir, if you'd please state your name for the record.
Alan De La Rosa.
All right, Mr. De Rosa, the floor is yours to conduct your cross-examination of this witness.
One moment, Your Honor.
Miss Kindred, did you know Blair prior to the investigation?
No,
What was the day you went to investigate the scene?
December 28th.
Why would you wait so long after the fire?
That was whenever I was able to go investigate it.
Why were you not able to go earlier?
I'm a very busy person.
What could be more important to you?
My health, it's very dangerous. I have to wait until they tell me I'm allowed to go in there and inspect everything.
Was anything electrical damaged?
Yes,
What could have been damaged?
the copper wiring was missing, so it was damaged because it was taken out.
Was the downstairs electrical panel damaged?
No,
So could it have been an electrical fire if the main panel was not damaged?
yes,
How?
because it wasn't just a downstairs panel where the electric circuits go throughout the entire house.
But if it was an electrical fire, if it was an, if it was an electrical fire, wouldn't the main panel be damaged?
It came from the lithium batteries, so it could have just been the upstairs in the garage. I never said it came from the panel in the basement.
But the lithium battery was not connected to the main. Oh, it was connected to the main panel in the basement.
I'm sorry, can you restate that?
Okay. The battery is connected to the main panel in the basement, correct?
Yes.
So if the battery was connected to the main port, wouldn't that have damaged the main port in the event of an electric fire?
The battery was damaged and it did cause the fire, but just like the whole house didn't burn down, it's not like all the circuits in the house got ruined by this fire.
But nothing in the main panel was damaged, correct?
No,
Why is that not correct?
no, nothing got damaged.
So that is correct, that nothing was damaged?
I'm sorry, you're confusing me, sir.
So when I asked that the main port is damaged, is it not damaged? Is that correct?
Are you talking about the panel in the
The
basement?
main panel in the basement.
It was undamaged.
As an expert, can you explain to the jury how an electrical fire starts?
It starts by something in the circuits going wrong. And there's sparks that come out from it and it causes a fire. Especially with there being more diesel and other fuels in the garage, it's not good for sparks to be flying around.
Can you give a more detailed? As an expert, shouldn't you be able to give a more detailed explanation?
Yes, I should, but these people are experts. If you wanted me to tell it in my expert opinion, no one else would understand. And I shouldn't have to explain completely how it started because there's no reason to go fully into detail with this.
But without explaining what could have caused it, how would we know it's an accidental or an electrical fire?
I already explained how I think it started and what caused it.
How do you know about the gas and diesel?
It was said earlier this morning.
So you did know about it prior, correct?
Yes.
But if you investigated this, wouldn't, wait. If you investigated the scene, wouldn't you know there was diesel and gas?
I said that earlier. I know that there was diesel and gas.
But earlier you stated that you did not know there was diesel and gas
When?
a couple minutes ago.
I don't recall.
You don't recall when we asked you 2 minutes ago?
Can you say exactly what you said to me 2 minutes ago? What you asked me?
Did you know there was diesel and gas prior to this event?
Yes. You asked me how did I know about the diesel and gas. I said we said it this morning. I also knew from investigating the scene.
Were you personally there at the scene?
Yes.
Okay. Can I have you read some lines from your statement?
Yes.
You have to take it with you.
Read lines 28 and 32. 28 through 32.
Part of my investigation, I have reviewed the following evidence: report of fire marshal and inspection of the Tesla Cybertruck, witness statements, photographs taken by fire marshal, photographs taken by the neighbor, video obtained from local CBS News, inflate witness statements, and download of the vehicle's electronic data. I also saw the invoice of the work order that the electric eel supplied about the work they did on Roger's house.
So you only reviewed the other information and not the actual scene?
I did not say that. That's not in my statement. I said I reviewed everyone else's. Nowhere in my statement does it say I did not go and review the scene.
No further questions, Your Honor.
All right. Would the defense like to do redirect?
No, Your Honor.
All right. In the absence of redirect, the witness may stand down. All right. Does the defense have any additional evidence it would like to put on at this time?
Your Honor, are we allowed to recall witnesses?
Generally speaking, not. Who are you wanting to recall?
Blair Rogers.
For what purpose? Rebuttal testimony is permissible, but I'm going to need to know what you're trying to rebut.
For more clarification.
Of what?
For house wiring.
What specific, you cannot use Blair Rogers to rebut statements that your own expert put on because she's not an expert. So what are you seeking to rebut? Use Blair Rogers to rebut.
Something in her statement.
And that something is?
That she did rewiring around her house.
Well, you could have asked about that on cross when she was called. So does the state have an objection to allowing for the recalling of Ms. Rogers?
Yes.
And your basis is that because they already had full
The chance to bring it up in cross and recross.
All right. So you would object to recalling of the witness?
Yes.
I will sustain the objection. So is there any other evidence that the defense would like to attempt to put on at this time?
No, Your Honor.
All right. So the defense rests?
Yes, Your Honor.
All right. So then I will yield the floor then to the state to make its closing argument.
Your Honor, members of the jury, opposing counsel. As you know, my name is Brody Keller, representing the state in this case. The evidence is spoken and it's clear. Now it's your turn to listen. Throughout this case, you have heard from our expert, a witness, and our victim. Our expert, Ms. Maldonado, talked about in her investigation, she found V burn patterns indicating that the fire was set deliberately by the defendant. She also found in lab reports that the fire had diesel involved in the fire, which was not in the garage prior. You heard from our witness, Professor Drew Bellow, Blair's next door neighbor, who saw Chris entering the house during the time he was said to be at the movies, out of breath, as if he just ran from the movie theater in which everyone else was at. Then seeing him walk away after the firefighters had gone to the scene of the crime. And last, you heard from the victim, Miss Blair Rogers, the poor young lady who lost her vehicle, parts of her childhood home, and a friend. She spoke about the sports bet that happened, and that after she won, everything had changed between them, out of jealousy. Then, after a careless act of the defendant not caging his dog was struck by her vehicle, which added fuel to the fire, if you know what I mean. As well, it was clearly seen in the original statements of Chris that there was a gap in his story. For these reasons, after you've heard all of the evidence, at the end of this trial, we will ask for you to return the verdict in favor of Blair Rogers and find the defendant guilty of arson on both counts. Thank you.
Right. Floor is open for the defense's closing statement.
Ladies and gentlemen of the jury, you have heard the testimony and the heart of this case. All of this points out to one clear truth, which is that Chris Johnson was not present at the scene of the fire or involved in making the fire. You have seen the evidence of the movie tickets that show there was no re-entry. There was no way for Chris Johnson to leave the movie. Photos of the fire, blueprint of Blair Rogers' home, and the official origin and cost report by Jess Maldonado. The vast amount of evidence points to his non-involvement in any way, from the fact that he was not in the area when the incident occurred. He was at the movie marathon with Riley Goldman, out of the house, away from fire, and with no reason to commit this crime. We have shown that the timeline does not add up. We have shown the electrical issues with the house confirmed by expert analysis, giving these thorough results and lack of contrast evidence. It can be said with confidence that Chris Johnson is innocent in this incident that he has presented. He has no malicious motive and provided a strong alibi that supports his innocence. The other side may believe that Chris Johnson is guilty. However, ladies and gentlemen of the jury, I would like you guys to think of one simple question. Why? Why would Chris Johnson, a practicing and student of law, commit this crime? We have proven that this case goes much beyond fire and smoke. It is a search of justice and truth, which is that Chris Johnson is innocent. We fully trust you to think things thoroughly and decide on the best course of action, taking into account the long-term effects. For the major impact on this young man's life that could end right here due to false speculations. For these reasons, after you have heard the evidence, at the end of the trial, we ask you to return the verdict in favor of Chris Johnson. Thank you for your time.
Counsel. Members of the jury, having seen and heard all the evidence and the arguments of the attorneys, it is your duty to find the facts and to determine if defendant is guilty as to each count of the indictment. You should consider all the evidence, the arguments, contentions, and positions urged by the attorneys, and any other contention that arises from the evidence. To find the defendant guilty of a charged count, you must all agree that defendant is guilty. You must be unanimous in your decision regarding the defendant's guilt for each count. You must make an independent and separate determination of guilt for each count. My role now is to explain to you the legal principles that must guide you in your decisions. You must not substitute or follow your own notion or opinion about what the law is or what it ought to be. You must apply the law that I give to you, whether you agree with it or not. The defendant, Christopher Richard Johnson, has pleaded not guilty to each count of the indictment. He is presumed innocent until the state has proven his guilt beyond a reasonable doubt. The fact that the defendant has been charged is not evidence of his guilt. The burden of proving that defendant is guilty belongs to the state, not to the defendant. Chris Johnson has no obligation to present any evidence at all or to prove his innocence. The entire burden or obligation of proof is on the state to prove the defendant is guilty. This burden stays with the state throughout the trial. In order for you to find Chris Johnson guilty of a charged count, the state must prove every element of that count beyond a reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt or to a mathematical certainty. A reasonable doubt is a fair doubt based on reason, logic, common sense, or experience. It may arise from the evidence, or from the lack of evidence, or from the nature of the evidence. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. If, having now heard all the evidence, you are convinced that the government proved each and every element of a charged count beyond a reasonable doubt, you should return a verdict of guilty for that count. However, if you have a reasonable doubt about one or more of the elements of the offense charged, then you must return a verdict of not guilty of that count. The defendant has been charged in count 1 with the offense of arson. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of arson or not guilty. To establish this charge, each of the following claims must be proved beyond a reasonable doubt. 1, the defendant damaged a building that is a dwelling. 2, the damage done to the building was by fire or an explosive. 3, the damage was done to the building, the damage done to the building was knowingly done by defendant. 4, the defendant did not have an interest in the building. And 5, the defendant did not have the consent of an interest holder to damage the building. If you find from the evidence that the above elements have been proved beyond a reasonable doubt, it is your duty to return a verdict of guilty of arson. If you do not find so, or have a reasonable doubt as to one or more of these things, it is your duty to return a verdict of not guilty of arson. The defendant has been charged in count 2 with the offense of arson. Under the law and the evidence in this case, it is your duty to return one of the following verdicts for this count: guilty of arson or not guilty. To establish this charge, each of the following claims must be proved beyond a reasonable doubt. 1, the defendant damaged property belonging to Blair Rogers. 2, the damage to the property was done by fire or an explosive. 3, the damage done to the property was knowingly done by defendant. 4, the defendant did not have an interest in the property. And 5, the defendant did not have the consent of Blair Rogers to damage the property. If you find from the evidence that the above elements have been proved beyond a reasonable doubt, it is your duty to return a verdict of guilty of arson. If you do not find so or have a reasonable doubt as to one or more of these elements, it is your duty to return a verdict of not guilty. I wish you the best of luck in your deliberations. You may now retire to the jury room to deliberate. So then, this way, folks.
What? Why didn't you object to any?
I didn't.
Exactly, but
So
why?
guys, what'd you think?
I'll never do it out of 10, we'll do again.
Did we do better than last year?
Yes. I'm impressed you guys came out and showed you did the work.
What?
Said you guys came out and showed you did the work. Good job.
I did good with substantial preparation that I had.
You had some stuff that you should have also raised that you didn't, that you had some material that was brought up. Yeah, okay, so what did you guys think you screwed up? We'll start. Addison, anything that you think you messed up in your pitch?
Better with my questions.
What do you wish you would have asked? Okay,
Mainly him though, because he was the one that.
all right, so Jaslyn, anything you wish you would have done differently with your witness?
Probably done more with the recross and asked more
About?
specific rewiring and brought in her statement.
You could have asked that on cross.
Yeah.
That goes to credibility. That goes to your theory of the case. So, yeah, there's some stuff that should have come up that didn't.
Yeah.
Every single exhibit that you guys got was there for a reason. So that you guys only admitted half of them, while better than last year, you guys were still leaving stuff on the table. I mean, you guys were arguing about times when the Harry Potter movie marathon, that's an exhibit. The start times were an exhibit. You guys could have admitted that and let the jury keep, more importantly, let the jury keep that. That's the purpose of admitting the exhibit, is this so that the jury can then look at it. Because juries generally can't look at exhibits. Can't look at anything except an exhibit. So for example, I mean, the second Harry Potter film was Chamber of Secrets was 3 hours. 3 hours between the start of Chamber of Secrets and Prisoner. That's 90 minutes. That's 90 minutes that there was evidence in the problem to support. So anyone feeling regrets that they made a tactical mistake that they wish they hadn't? Well, you guys have had it. You guys have had the problem for. And you could have asked Blair, or you could have asked the defendant, or Riley, and you guys could have stipulated the facts that this is a true and authentic copy. Because even if you, and that's what I was fishing for on questions about, do you have any other evidence you'd like to try to get in, was if you guys wanted to stipulate to exhibits. Because all the exhibits are stipulated to be authentic anyway. But I'm kind of surprised nobody tried to use either way the stuff from the PSI. Why didn't you want to use that? Seal clubbing?
What?
Too much seal clubbing?
What's that mean?
What you saying?
No.
It would have meant that the task was already easy. Why it would be unfair to club baby seals with it.
Oh.
Yes. Nobody got confused about who they were. I mean, nobody pressed Drew, nobody, as I can see, Dr. Bellow quite clearly, who looks quite good, who got into the spirit of things. Nobody pressed him on the fact that he's a quack.
It's good for us, though.
Yeah. Also, nobody pressed Riley on the fact that she sounded like an entirely different person.
I'm not guilty at all.
Just ask random pop culture questions, and when she doesn't answer them, you just point to your witness statement and say, this is what you expressed in your witness statement. Who's the best dwarf in Westeros? Who's the best dwarf in Westeros?
What?
That's not in my statement.
Who's the what?
Yes, it is. She says she prefers Tyrion to Jon Snow. Who is the best dwarf in Westeros?
How? No.
One, that's hilarious for several reasons.
It's because I was trying to think of his full name. Peter Dinklage.
Yes, Peter Dinklage played Tyrion Lannister.
There we go.
There's a statement that, she prefers Tyrion to Jon Snow. You ask those kinds of questions to set up, to impeach Riley's credibility. If you were up here today making no pop culture references sounding like an entirely different person, pointing out that you don't know anything about pop culture just because of who the person playing the character is, that still goes to Riley's credibility because her witness statement is.
Yeah, let's make sure. Jeez, make sure.
So far, YouTube says nothing. Sorry, girl. I should have said no. 15 minutes to take now. It's okay, though. I'm hungry.
Come on. There's polls on YouTube. Wait, where's the poll? I want to see you.
There's a poll. Yeah.
If he's guilty or not.
So you're running a poll to see if that's actually funny.
If only we could have you on the side.
What are they looking at?
How many voted? Are you looking at how many people?
Has the state proven defendant guilty beyond a reasonable doubt? Yes for count one only, yes for count two only, yes for counts 1 and 2, and no.
They voted no on all of it?
No, only one person has voted so far, but they voted no, yes.
I wouldn't bet you it was my mother.
I need to go vote.
Yeah, that's. I'm really looking like.
That's a huge screen.
Next year's trial should definitely skip the jury. It'll be a poll.
Just have YouTube do it.
Yeah.
Okay. Okay, little birdie.
They're criminal. Yes, they're guilty. You're going to jail.
Look, guys, you got your first two are
Whoever that
of
person
the
is, they're brave.
I bet you it was the name.
Yeah, that was,
Only one person voted for it.
One
I know.
person voted no, 7 voted
I think
yes.
that should be taken into account.
You're cooked.
Well, I had
Yeah,
to
so-
go over here.
Yeah,
I felt sorry.
I'm sorry.
Yeah, sorry about that.
We all did it as a team, Alan.
I had to let you.
That one right there. That one right there.
No,
Somebody weighed in and said yes to counts 1 and 2.
I was assuming it was Evan.
No, Evan didn't even vote. My phone out. We can't have our phones. Yeah.
I
don't like
I do.
Bang.
I wish I hope the camera caught me with my head in my hands when I was like.
50 points off. Everyone that was making faces, 50 points off.
No.
Everyone that was making faces and all that.
How do you know?
They said before we walked in, you're gonna get 50 points if you made faces or anything being dramatic. Yeah. If you made dramatic.
that's everybody that.
That's everybody.
Everybody. I laughed.
Ellen, even you made it.
Don't even you now.
Yeah, you did.
Yes, you do. Everyone.
Yeah. You can't. You're not. Oh, Jocelyn, we're giving you the responses.
Minus a bit of pressure.
Like, it hasn't even started. And you're like, you need to. Don't say that.
You can't.
You're on my last one.
You want more straws? I can give you more straws.
Colin, you're probably gonna get it.
The good
thing is
that
You are not passing. You are not gonna get that
Decent play and better than I.
Oh, my bad.
I get it. I lost and stuff.
I don't think all nobody's gonna say like. That's all right. You wear them. Kenzie, nobody cares. I care. Why? I said that about back here. It's let me act like that. I do the best. No. Don't listen to anyone. Don't listen to anyone. I feel like what everyone said about me. Just all of our fault. We could have prepared. We could have prepared. Needed in the first.
We were so focused on him that we forgot to focus on the
Don't let this make go there.
Yeah, like, we did good.
I did. I just, I'm gonna. I knew it though.
Yeah.
That one whenever I just said yes, I knew that what I was.
good winnings trap. All I can hope is that you guys vote me to go into holding.
Real.
I'll eat a sandwich if it's cold bologna.
Just your whole side goes because they don't want to pay.
Oh, yeah. This one, my dude.
Thank you for the silver platter.
Hey, it's not over yet, guys.
It will be.
It will be soon. Not over yet.
And nobody gave the witness, nobody gave Hesmar any crap for what he's wearing.
No, Your Honor.
Yeah, why not?
We should have, like, why did?
Why didn't you?
Is this not important to you? Why did you dress so nonchalant?
All very good questions.
Should have.
Much like the question that I wanted to ask, I wanted one particular question.
What's that?
What?
Yeah, we were.
No. No, but that was one of the things that I did notice that it was not really harped upon that the Drew Bellow saw him in the same clothing. That's kind of important. That's kind of important.
Left jab.
No, I'm just, I know, but it's for the same reason. The question that I wanted to ask was, Mr. Big Dick, did you send any of these photos to Blair? Because that's not said. That's not said one way or the other. And that was put in there specifically because you guys were the ones who were reading sexual tension into their relationship. No, the supplementary, from the PSI. No, then you need to look at it right now. You need to look at it right now. You're gonna facepalm that you didn't use the material out of there.
We make you feel dumb if you make yourself feel dumb. I think we all just.
There's a reason why I gave you a weekend. There's a reason why you got a weekend. I'm just saying it was no, go look, you need to go read it right now. Do I need to print it out for you? Well, like I said, it would be easier just to have it printed out. Well, if you're a computer guy, that's, it's totally.
We were in a sense.
No, it doesn't work like that. Doesn't work like that. Has to be unanimous. It means that Hesmar could log onto his phone and vote no, and it would hang the jury. So no. Not that I think Hesmar would do that, but you know what I mean. It would be.
No, they did. We did that. All of us. Where are you going with this? But that is something you don't know.
I really hope my kid doesn't.
But it did have.
No, but it might have just picked up that when you said that.
Okay, so we could have turned this into like,
You could have turned that into questions and examination of him, yes.
we could have really made him look like a bad person.
That's why it was there. Well, most of it was probably inadmissible. Unless you guys have really gotten into the rules of evidence and were to make some arguments. But yeah, it was there to entice you to want to use it.
More evidence for each other.
And like I said, the question that I purposely, my question that was a great question for today was, well, Ms. Rogers, did Mr. Johnson ever send you any lewd pictures? And I would the answer to be yes, because that's hilarious. That's hilarious improv. But you guys didn't go there. There was a lot of stuff you guys left on the table.
Well, yeah, we didn't use the picture of Esmar saying that he burnt down the cyber.
No.
Yeah.
No, how were you going to contest it though? It was
from him.
It was
Sent it.
He created it. Well, he created it and shared it with his, no, your problem was it was a group chat with everybody. You have a darn good privilege claim if somebody on your team, if it was a private chat of just your team, and so, well, it's not on it. It's a group chat with everybody. No, that's privilege. That's privilege. You guys could assert privilege on that. You guys could have absolutely asserted both attorney work product. Well, not attorney work product. You could have asserted attorney-client privilege. But if that was available on Snapchat, like for the public to see to begin with, that you're gonna have a hard time arguing privilege.
Wow. There was some other stuff that we could.
It's what? It's what? Yeah, but again, that's what I didn't like about it was, no, that's something that we could have done. If this was 2 months ago, we could have done all kinds of stuff with that. We could have had all kinds of fun with that, making that part of the problem. Well, no, I was ready to do it. I told McIntosh, do you want me to do this? And, do you want me to spend all Monday night getting this in? And he didn't respond to me, so.
I find that I hope the next teacher doesn't.
He did fantastic.
Well, was it fun?
Yes.
Okay. And you would recommend that it keep being done every year? How about over here? You guys learned some stuff, hopefully?
It's fun getting to see my clients.
Hoisted by his own petard?
Yeah.
Yeah.
What basis did he have to object? It went to credibility. Most of it went to credibility, which is always within the scope.
But even then, like you said, stop bleeding over my health, but I didn't do it. But now that's not my bleeding.
What's YouTube saying right now? YouTube is at, it's 50-50. We have
How many votes?
4 whole votes.
Wow.
Well,
It's okay.
we currently have 26 concurrent watchers. We peaked at 38. So no, it's been a pretty good watch day. I mean,
Yeah, at least they were.
My mom and dad were probably watching.
I know
My mom. Yeah.
Bro.
takes them as long as it takes.
Hey, you said she got the call at 9 p.m., but I was waking up until 9 p.m. You were by then.
Ran out of
Yes, I ran out of gum.
Oh no, are we gonna have another trial just for the gum? We could do a mock trial, a little one. Oh my gosh, Evan, now they're.
Oh, yes.
You better be smart like this where you come out in.
Yeah, you.
The potato skins.
You want to see it? Have you seen the one where he's upstairs? He's like, hey guys, friends.
I'm not. Why?
Evan, you broke it.
There it is.
Or if he calls me guilty right there, I might just like run straight in. There's so many good things I could do right now. What is that? Yeah, I know. That's so dumb. You guys added that, he added that at the end. That's how I knew we was gonna race. We didn't even use it. We didn't use the, yeah, that's what I was telling them. I was like, I'm glad they didn't use it. I thought you guys were gonna say something if I didn't put Richard. I said just Chris Johnson. But if I would put Richard, you guys would have took it. No, we're not.
We got good.
I'm gonna be spending it.
Actually, we didn't.
It's fun, bro. What you mean? I wonder how many fun. I wonder how many times it was fun. It was. It was so fun. I should have done better. I think you did good. It's hard. I don't know how to talk like that. But it was so fun. I tried to dress like an nerd. I should wear tennis shoes. Put socks on.
They didn't ask me.
Yeah.
And then he was like, all right,
Especially when his sister.
Definitely his outfit.
Yeah,
that was only thing. No, that was only.
Bro, I'm so mad I started laughing. Red? Yeah, red seconds maybe. I'm so mad I started laughing. I like the bow ones too. But shit, you come up from the jury too. They were the reason they made me. And Felipe the entire time I walked there. You're so dumb. Why would you say that? Like, shut up.
He should replace it all.
I think we did okay. I don't think we did too bad.
We did better than last year, so.
Well, as long as just everyone played their part.
Even if some of them did it far worse than others.
All right, that's enough. Everyone did fantastic in my eyes.
You must be blind then, to that man.
Yes, he is. All the other people. Did you
guys hear the Snapchat?
Is that you?
No,
it's not.
there.
Who got you on highway? It was unfortunate. We walked all the way to how far is that?
Yeah, you shouldn't even went after you just
Like 2 miles.
It is not like 2 miles. Maybe like a road you?
It's literally like you drive this way so long, then drive this.
No, it's not.
Yes, it is.
You and what?
County Road U. That's it.
There's no like,
60 Southeast County Road U.
so you don't even hit a crossroad?
Yeah, you do. It's like the road going to Fargo, you know? On the side.
I know, so you go down the highway and you turn left. No, you turn this one.
You turn that one. Yeah, if that's out.
Yeah, the highway's going east and west. You turn south, and then you turn west. Where is it by?
You look good in those.
Scott?
Or you need to go to the eye doctor.
far
You
is
have
it?
needed to for like years.
10-ish minutes.
Doesn't matter what song you're gonna sing.
Like to get to my house.
I'll be playing.
From my house,
In 6 minutes.
from my house to the train track is like 5 minutes, and then from there to town is 10 minutes.
After Michigan State.
On what?
Free trial.
You walked like 10 minutes in the rain?
No.
I lost like 3 minutes. Her road's like, Petron's like 5 miles. 6. How many miles? Hello. This is Brianna. Oh my, a mug shot. When you go down the train, it's like this. You're coming back. Get in your face, get in your face. No, no. No. That's why you're staring. Sorry, you're going to jail.
Yeah, Felipe, it's not it.
Yeah.
And with that too. So it's a W in the butt.
What's our monthly budget? We're not there. Well, there's match. Is it normal that my heart comes in? No? I think Mr. Wilson did.
Yeah. Yeah.
We did.
You don't get on it.
All right, well, juries are usually summoned to return. They do not return of their own volition. But as the jury has taken its own initiative, then I will simply go around the horn and we will see what is done as we tally the votes. All right, so jurors, 1, starting with the foreman, 2, 3, 4, 5, 6, 7, 8, 9, and 10. And so first 5 in the front row, starting right to left, and then 6 through 10 are in the back. Juror number 1, with regard to count 1, do you find the defendant guilty or not guilty? All right, juror number 2, juror number 3, juror number 4, juror number 5, juror number 6, juror number 7, juror number 8, juror number 9, juror number 10. All right, with regards to count 1, the jury has unanimously arrived at a guilty verdict of arson, a severity level 6 person felony. We will repeat the same procedure for count 2. Count 2, juror number 1, guilty or not guilty? Juror number 2, juror number 3, juror number 4, juror number 5, juror number 6, juror number 7, juror number 8, juror number 9, juror number 10. The jury has unanimously returned a not guilty verdict for count 2. All right, on that basis then, we will bind this defendant over immediately for sentencing in this matter. Right. Upon defendant's conviction of the crime of arson, a severity level 6 person felony, as the jury, it is your solemn task to determine the punishment of the defendant. The state of Kansas entrusts this duty to you, the defendant's peers, in the belief you will exercise the same dispassionate objectivity which you have exhibited in rendering the verdict in this matter. The state of Kansas mandates the defendant be sentenced to a period of incarceration with the Kansas Department of Corrections as a consequence of this conviction. It is your task as the jury to determine the length of that period of incarceration. Based upon defendant's criminal history, the mandatory minimum term of imprisonment you must impose is 37 months. In determining but you may impose a longer duration if you believe the defendant's conduct was such as to warrant a greater punishment. The maximum term of imprisonment you may impose upon defendant is 41 months. In determining what underlying prison term you believe appropriate, you may consider any or all of the evidence which you have heard today. You may also consider other such factors as you consider appropriate, such as defendant's age, the chain of events which led to the proceedings today, and the impacts which defendant's actions have had both on the victim as well as the community. Your purpose is to decide a punishment which you believe is both commensurate with the crime committed and appropriate for the particulars of both the case and the defendant. In the course of your deliberation on the underlying prison term, you may also consider whether you wish to grant defendant the possibility of early release from prison. Under normal circumstances, for a crime with the severity of which the defendant has been convicted, a defendant is eligible for parole and can reduce his sentence by up to 15% with good time credit for being a model prisoner. If you determine that defendant shall be eligible for parole, then you may also determine what percentage of good time credit he is entitled to. However, that is only a recommendation to the court, and the court is not bound by any recommendation with regard to eligibility of parole. You may also, in your deliberations on the underlying prison term, also consider whether you wish to have defendant serve that underlying prison term. The law of the state of Kansas allows the jury to recommend to the court the defendant be released without serving the underlying prison term, provided the defendant abide by certain conditions for a certain period of time. This sentencing option is referred to placing the defendant on probation. Should defendant abide by the terms of his probation, the underlying prison term shall be deemed served at the conclusion of the probationary term. The standard terms and conditions of probation are established by statute and must be adopted by the court. But the jury may make determinations regarding particular special conditions it wishes imposed, as well as the duration of probation. The standard term of probation for count 1 would be 24 months. Unlike with the underlying prison term, you may only recommend to the court that a sentence of probation be imposed. I am not obligated to follow your recommendation on whether probation should be granted, as well as whether any special conditions be imposed or what the term of probation should be. You must, as a whole jury, arrive at a unanimous sentence for it to be imposed. In the event you are unable to reach unanimity in deadlock, the court will inquire with each juror as to their preferred sentence in open court, as was just done with arriving at a verdict. After which, I will take your combined preferences under advisement when determining and imposing a sentence upon the defendant. Having been advised of your responsibilities in determining the defendant's sentence, you may once again retire to the jury room for your deliberations. So what we've established is the internet knows nothing. Well, no. Let me guess, another creation of the defendant? Well, if you want to gloat, you're welcome to hang it up.
Yeah.
When the poll closed, we had 6 votes. 3 found that the defendant his guilt had been proven beyond a reasonable doubt with regard to counts 1 and 2. And 3 found that his guilt beyond a reasonable doubt had not been established at all. Well, the jury ended up splitting the difference and convicted him of 1. Which is a defense. It is a defensible verdict. There was buried within the final expert's testimony, there was reasonable doubt, or at least defensible doubt, with regard to the brain fart. There was doubt with regard to the Cybertruck. Because if it caught fire itself, which Cybertrucks are known to do,
The other
So.
side decided who they're gonna send with Hesmar.
Whoa. I ain't going anywhere.
well, I don't know. I believe on Mr. McIntosh's agenda is figuring out whether you're going to be hauled over to the sheriff's department for a period of 37 to 41 minutes.
Bro, I wanna eat.
You're gonna eat.
Well, then you can blame the rest of your team.
I hope they have mashed potatoes and brown gravy.
No. Sometimes.
You better hope today's.
That's Mr. McIntosh's bailiwick, not mine.
I promise you,
Days it's a warm meal.
if we're during lunch.
On the
mine-
weekend, that's fine. So you're like, I mean, it's not weekend. You get a warm meal, not a sack lunch. At least I'm not warm yet.
You went to go, I rubbed off my nail yesterday.
Oh, is that why you weren't standing? You at the pool?
My gosh.
We should like.
4.5. 14 strap.
You have more of these, Evan?
Okay.
Just now? No, I don't. And I'm allergic to bandages.
Well, he's getting
Joining.
Better hope it's 37 minutes.
I better hope it's 5.
No, they're gonna make you like. They're gonna make you get in there.
I hope so.
until
I don't
we're
have to
done
return to
eating.
school.
Oh, now you wanna go to school. Now you wanna go to school.
I hope I'm in there the whole day, so I don't like that.
There's no way this will take this long.
You didn't shine your shoes, that's why we didn't win. I got some shoe polish for me.
But yeah, you want me to go to jail with my polish?
Leave an imprint.
Dude, I'm so.
Alvaro, get me a hamburger. Give me a hamburger.
What do you guys gonna go to jail by the time you get out? Yeah, you're.
Hey, start getting Blair.
Hesmar, run. Run, Hesmar.
Use some
Who's going with him?
You.
Me?
Yes. Yeah. Yeah, so. No, I know.
Oh, yeah.
They talk.
So. Rock, paper, scissors through the jail cell.
No, I think we're gonna be in the same cage. Like, I want to.
Cage?
They're just gonna put them. You want to go?
Yeah, that's
We're just gonna be like, we're even talking about the child, we're
I'll
gonna
be
be like,
like,
well.
so what do you think went wrong in the trial?
Let's call it to Kenzie.
Oh, no, let's rock, paper, scissors, and see who would, rock, paper, scissors, shoot. Rock, paper, scissors, shoot.
Ah,
And you're going to.
and because the Kinsey souls.
Honestly, I'm not a fan.
I think it's sold.
I can.
Yeah.
They're just mad I did my opening statement better than graduation.
I think you have to wear orange every day until we graduate.
Low key, I'm not mad at you.
Nah, me neither. Yeah, the pub's low key sounds, the pub isn't that good. But
Yeah, you
I like-
tell your
better
like
than-
that.
I like the cherry temples.
You can eat Shirley. Extra, can I get a Shirley?
If you ever, I wanna ask for 2 PB and J. You wanna give me 2? I bet.
I'm gonna get children, bro, you peanut butter.
No, they better be giving me 2 PB. Oh, yeah. There's no PB, man. Hey, have you ever feel guilty? You know what? I'm gonna, the cellmates, I'm gonna like.
What time?
Hey, guys, we're just gonna pinch on it. Exactly. Hold that up. No, bro, we're gonna start.
Like-
drawing on the wall.
Hey, let's pull up. We're gonna sit.
I don't know if I can do that.
Oh, you're good.
Ready?
Guys, look professional. Dude, look
Have
professional.
you?
Okay, all right, bet. I pull out the box.
What? Hey, he has a gun.
That's it. Going.
Hey, you guys can hold up the L's.
We ready yet? Yes, sir.
Gotta get my side picture in. Oh, wait, let's see. How we got. Oh, me and my client.
Me,
My lawyer.
me and my defensive lawyer are going to jail.
Yes, sir.
That's what they voted.
You guys should have all agreed already. Yeah. No, I'm not gonna pull you guys. If you guys have a unanimous verdict, I don't need to pull you guys.
Not a big deal.
Has the jury reached a unanimous sentence in this matter? Mr. Foreman, if you please stand. On the subject of the underlying prison term, what is the term of imprisonment that the jury has unanimously agreed the defendant should serve? Right? And has the jury reached a recommendation on good time credit? And that is? So your recommendation is 50? All right. That he be eligible and with 50% good time? All right. And is it your recommendation and do you have a probation recommendation? You don't have a recommendation or you do not recommend probation? All right. All right. You may have a seat, sir. Thank you. Thank you for your service. The court, having been advised in this matter by the pre-sentence investigative report prepared by court services, which found that the defendant's criminal history to be a B, and which would place him in the 6B grid box, finds that the recommendations of the jury are in the interests of justice in this matter, for the most part. So the court will therefore, under the laws of the state of Kansas, sentence the defendant, having been convicted of the crime by a jury of his peers of arson, a severity level 6 person felony, to a period of incarceration with the Kansas Department of Corrections for a period of 37 months. Defendant shall be eligible for parole and be entitled to the guidelines 15%, not the 50% recommended by the jury, as I do not believe such factors have been established in this case that would warrant a departure from the normal good time credit in this matter. Defendant shall also be subject to post-release supervision for the standard period of post-release supervision for the standard period of 24 months upon release. I shall also order that the defendant shall pay restitution in this case in the amount of the damage to the garage for which the defendant has been convicted of burning. While no evidence has been presented of that, it has been established beyond reasonable doubt that the defendant was the instigator of the damage. So the defendant will, as part of his post-release supervision, pay that restitution. And in the interim, the court shall order that the victim, in this case, Blair Rogers, ascertain the precise damages and report that to the Department of Corrections so that when post-release supervision begins, that restitution amount can be properly enforced against the defendant. Is there anything further that we need to address at this time in this matter from the state of Kansas? From the defense? Now, the defendant is entitled to appeal both the conviction and sentence in this matter. That appeal must be made within 14 days of today and will go to the Court of Appeals in Topeka, Kansas. In the interim, I will remand the defendant to the custody of the Hamilton County Sheriff's Department to await transport to the Department of Corrections. And on that basis, Sheriff Wilson, if you would please be so kind as to take custody of the defendant. Hearing nothing else, then we shall stand adjourned in this matter. We are adjourned. Now, Mr. McIntosh, is somebody else going with the defendant? And who is that? Why is Brissa actually did good?
What did I say?
No.
Did I change it? I just found I was really good at my part. I did my opening statement, no guidelines needed. I had to remember.
Do it quickly.
You should not listen.
No, just leave it, just leave it, just leave it, just leave it. Just leave it, no, just leave it. Just leave it.
Yeah, no, yes.
A more fitting. All right, so having completed mock trial in this event, we are in recess, which means you go where Mr. McIntosh tells you, but I believe that is over to the pub. And I would like
a small victory for me.
And I like to thank everybody for joining us on YouTube today. It's always a privilege to have folks coming in from the community. Thank you very much and have a wonderful time, everybody. Thanks.
Everyone, you guys see the weight down at the bottom here? We're not supposed to take them. Weight down at the bottom.
Don't take us.
I know what, having to go over there is insurmountable.
Happy.
And I've been plugging.
I've been like 37 months. There's water bottle there, there's water there. I was gonna say, as long as. Make sure everything's picked up there.
Yeah.
Yeah, about that.